Just taking it back. So from there it started. I worked part-time and worked full-time at Blue Shield and eventually had enough business that I decided I'd jump into real estate full-time and started. It's been a great career, but nothing I intended to get into, kind of like Mike's story. So again, I like lists. So there's a lot of stuff on here that you may not need or want, and I can show you what that is as we go through this. I did a lot of corporate relocation, so I had to have some, after a house settles with the corporate relo, we had to send stuff to the relocation company. So some of this stuff on the file, are you guys coming in, or are you just gonna make noise? You have videos. Are they bathroom videos? Here. Don't you see his videos where he's on one stall and talking to the person in the other stall? Henry. So I want this to be interactive. I want you guys to learn. We're going to go over all the listing forms and what you do. So I'm going to ask questions and then I want you to give me answers or simulate conversation. I always say we can learn from each other. We're all Keller Williams in here. So normally I give a speech that we can't talk about commissions because if we're multiple companies, that's considered antitrust violation. So we're all one company. I don't think we need to talk commission numbers, but if you need to, it's not going to be a problem. Remember the code of ethics. If you talk about a transaction, do not talk about the other agent in a derogatory way. If you have a question when I'm talking, just give me a quick hand. I'll finish my sentence and get to you. We'll take breaks. I don't know that we're going to need 2 days, but if we do, we'll run, or we just do shorter days, but we'll get through it all. If we need 2 days, that's fine. So when you get that phone call that you're going on a listing, what's the first thing you do? And everybody's different. What's the first thing you do when you know you have a listing? And you're getting ready for that appointment. What's the first thing you do?
I look it up on Bright, see the history of records.
Perfect. Look it up on Bright, get the history. What specifically, when you look it up on Bright, are you looking for?
Previous listings.
Previous listings, but what about the previous listing? What are you gleaning from that previous listing? So you're going on the appointment for 123 Main Street. You pull up 123 Main Street. What are you looking at?
Is that a condition?
Condition based on the photos of what was there when it was listed before.
How long they've been there?
How long they've lived there. What they paid for. I'm really looking for some seller's property disclosure. Prior seller's property disclosure statements. Why?
So that when you go to see them, and you go over all that information and they're not sure about things, you can go back and look at that. I go look at that one.
What's your new seller gonna have to fill out?
An SPD,
Right, and what did they get when they bought the house?
an SPD.
That prior disclosure. What else so when they're filling out their sellers, so the focus of this question is on the seller's property disclosure statement. So what does the seller know to fill out that statement? I'm looking for 3 things. This is when you give a seller's property disclosure, a blank disclosure to a seller, what 3 things, mostly, they could have 3 things. 3 things that they should have to help them fill that out. The prior disclosure.
Maybe a home inspection if they got something.
A home inspection when they bought it. That's the second thing I'm looking for. And basically what?
Any work done with house orders and such?
Their experience of what they did or what happened to them while they owned it. So their experience in the house during their ownership, they need to have that. They need to have the prior disclosure, because if they bought it, there was a disclosure, whether it was a for sale by owner or not, it doesn't matter. The prior seller, the only exception to that would have been if it's an estate, and estates still fill out disclosures. And what they know or they don't know. And that's the most open-ended one. What a seller knows and what they don't know, right? Because some sellers, I'm with a seller now on a property, and I went in and they said, well, we have some electric outlets that don't work. And I'm like, well, the house was built in 1991. Why don't the electric outlets work? I said, which outlets don't work? Show me. So we go upstairs to the primary bathroom. And of course, it's the one between the 2 vanities. And I'm thinking 1991, GFCIs were all wired to one outlet, usually next to the panel box or in the powder. So I said, let's go down to the powder. So we go to the powder room on the first floor and I push a button and she said, for 6 months, I've been drying my hair in front of the window, but all I have to do is push a button. So there's no clue that when an outlet doesn't work, it might be a GFCI, no clue. So that's always clueless. They don't know a lot about us. So that doesn't mean that their disclosure is going to be wrong. It's only what they know. So when I go on a listing appointment, the first thing I do is, of course, you get information about the house. But then what do you do? Like think of public documents, public record documents. Always, always, always pull the deed. Because if Becca Brown calls me and says, I want to list my house and I live at 123 Main Street, and I pull up 123 Main Street and the deed says Maggie Landis, why is Becca Brown calling? Who's Becca Brown in relationship to Maggie? Now she says, oh, I'm sorry. I'm Maggie's power of attorney. Maggie's infirmed and she's in a nursing home. Maggie's my sister. Then what do I need from Becca? The POA. And what am I looking for on that POA?
She has the right to the handle of real estate.
That she has the right to handle real estate. The POA could be very limited. It could just be that Maggie gave Becca her power of attorney to pay their monthly bills. That's it.
Or medical.
Or medical power of attorney. She doesn't have the power. So a power of attorney document, Maggie's the attorney. She is granted the powers that Maggie lists. She has these powers. Most times when an attorney draws up a power of attorney for someone, usually it's parents drawing it up, children having it drawn up for their parents. The parents give the children unlimited powers, but one of those powers has to be that they have the power to sell and exchange real estate. If they don't, you cannot list that house. Now what? They have to sell the house. Now what does Becca have to do to sell Maggie's house? If Becca wants to sell Maggie's house and she doesn't have a, can we bring that whiteboard up here? If Becca wants to sell Maggie's house and she doesn't have a power of attorney and it's her sister and she's her only surviving relative, what does Becca have to do?
To get to you. To come in, well, if it's someone in a nursing home, to go into the nursing home and verify that they're.
She'd have to be court appointed. She'd have to go to the court system and the county which Maggie resides in and be a court appointed guardian of her Maggie. And in that case, she would have the power to sell Maggie's house. So that would be through.
Is that if the person is not able to any longer?
Right, if Maggie can't give her those powers. Because if she just doesn't have it and Maggie wants to, if Maggie's her son and mine and said, you know, Becca, at first I only gave you the ability to pay my bill, but now I want to give you the ability to sell, I can give you all my powers because I trust you now. Then if someone she's the son, mind, and body, she can update her power of attorney. So the general concept that I'm trying to you can't sell a house until you know what the ownership is, period. How do we know ownership? The first one, deed. The first thing I do is pull the deed so that if Mike Braddock called me, Mike Braddock's name better be on that deed. Now, if Mike Braddock and John Henry are on that deed, I want to meet with John Henry and Mike Braddock because can I sell the house with Mike Braddock's signature? Maybe. How could I sell the house if it's Mike Braddock and John Henry with only Mike Braddock's signature? Think of what I just told you. Mike Braddock has John Henry's POA to sell his house. So if the deed says Mike Braddock and John Henry and Mike Braddock shows me a POA, now I could legally list that house. But what if Mike and John are feuding? When you go to settlement, the title company is going to ask about John Henry and they're really going to want John Henry's name. They want John Henry, if he's able to sign that deed. Also, with a power of attorney, if Becca's using Maggie, so Becca had Maggie's power of attorney to sell her house. She had that. That was one of the powers there. The title company, for purposes of what's called chain of title, the title company will probably record the POA first, and then behind it will be the deed. So that when you're looking for, when that house is sold again, they understand why the deed was signed by Becca Brown instead of Maggie, and then when you're dealing with a power of attorney situation, just remind the person holding the power of attorney that they'll probably have to relinquish the original power of attorney to be recorded when the deed's recorded, and they'll get it back. They will get it back. But just remember when you're working within a power of attorney situation. So for 90% of the transactions you're going through, Joe and Sally Smith are going to call you. Joe and Sally Smith's names are going to be on the deed. Joe and Sally Smith have to sign every piece of listing paperwork. That's normally what we get. Now we have Mike and Mary Braddock on the deed, and Mary Braddock passed away. Mike never had the deed put just in his name. So now to sell this house, what do we need on Mary? A death certificate to show why Mary isn't signing the new deed. Mary's not here. Mary's dead. No offense. I hope your wife's name's not Mary. Okay. So why isn't Mary here? She's dead. How do we know she's dead? We have a death certificate. That's all you need. So when there's two names on a deed and one spouse is deceased, you need the death certificate of the other spouse. Let's go one step further. Is everybody following me? Because I know I'm feeding you with a fire hose. I realize that. But just ask questions.
Thank you.
And I'm always here for everybody in our office when you're doing something. If you have a question, I'll always help you. So always, always, always pull that deed before you go on the appointment. And if you look at my checklist, the first thing I say, create an electronic file. So with every one of my customers, and this is just me because, like I said, I can be a little retentive.
Yeah.
I create an electronic file for the person, and there's all the documents that I pulled for their house, for their listing. I keep the photos in a separate file. This is in an HOA. I keep the HOA documents in a separate file. And I have the same naming convention for everything. So I create an electronic file on my computer, and then I go into Bright and create an opportunity because I know I'm going to have to upload my documents there. But the first thing on my checklist is look at the deed. So I want to finish talking about the ownership of the deed, and then we're going to dive into this deed for a minute. So we've talked about how we handle normal people. There's husband and wife, 2 women, 2 men, whatever the situation is. But everybody on that deed, if they're alive and of sound mind and body, they have to sign all the listing paperwork, period. If it's a husband and the wife died, or a wife and the husband died, you need a death certificate. If it's a different person calling you than the person on the deed, we need the POA. Now, if the deed says Mike and Mary Braddock, and Mike's son Steve calls me and said, I want to list my parents' house, Mike and Mary are both dead. So the 2 people on the deed can't do anything, right? So now what is it called? If Mike and Mary's son is selling their deceased parents' house, what do we have? An estate. So because Mike and Mary are both dead, with an estate, you need the death certificates of all names on the deed. So that's the first thing. I need Mike's death certificate and I need Mary's death certificate. Now, Stephen, go ahead.
Dora wanted to know, how do you find the deed on the MLS public records?
It's not there.
Thank you.
You got to go to the county records to find deeds.
Okay.
We're going to do that.
Perfect. Thank you.
Does somebody else? Okay. Now, Stephen called me and he said, Mike and Mary were my parents. They died in a car accident. I'm their executor. We're going to pretend that Mike and Mary have their estate planning all done. And they named their son in the event of their death, that their son would handle their estate. What do I need from Stephen? Go ahead. Say it again. Short certificate. A short certificate. Certificate. A short certificate is issued by the county prothonotari's office when the will is probated. So they take the will into the prothonotary, and the prothonotary, Stephen has to identify himself that he is Stephen Braddock. And here's the will, which Mike and Mary signed. And it identifies Stephen W. Braddock as their executor. So there's a short certificate. So that's the document you need to prove that Stephen can now sign the listing contract. You do not need Mike and Mary's will. You need a death certificate of Mike and Mary. You need Stephen's short certificate.
Is that a quick turnaround time to get that short certificate?
Yes, when the attorney takes Stephen to the courthouse, they get it that day.
Okay, thanks.
What if Mike and Mary died in intestate? No will. Now you got to go through the court process to have Stephen court appointed to be Mike and Mary's executrix, and that takes time. You cannot list the house until there is record of the person signing the documents that they have the right to sign the paperwork.
And if it's a husband and wife, but their son is still on the, so if the husband and wife passed away, he's still able to get that.
He can do it with death certificates because he's an owner. He's the only owner left. Now, it would depend a little bit on how that deed is worded. If it's worded with joint tenants with the right of survivorship, and as one dies, the state goes, but it could be worded that mom and dad and Stephen own the house, but if mom and dad die, their share goes to Stephen's sister. Now, Stephen's sister and him own the house. So technically, they both have to sign off on all your listing paperwork. And they could own it as tenants in common where they each own 50%, or they could own it as joint tenants with the right of survivorship. That's going a little bit deep, but you just have to pay attention. This is the most important document you can pull when you list a house. Period, the end. This is it. Get that deed. And we're going to talk about what's in that deed in a minute, which is why it's so important to pull that deed. But let's finish with an estate, because this is a whole different line of work. I've made a great living on relationships with attorneys by doing estate work, because I know everything that needs to be done. The attorneys know I'll get it done. And this is a great gig. A great gig. You need, every time there's an estate, you need the EIN number of the estate. So the attorney will apply to the government for an EIN number of the estate. The title company is going to need that before you can go to closing. You're going to need a Department of Human Services letter. What's this? Anybody know what that is? What Maggie is? Department of Human Services letter. What do you think that is? Why would the Department of Human Services in the state of Pennsylvania have a lien against the town? If they receive Medicaid dollars. Right. This letter says that, so the title company or the estate attorney will send the social security number over to the Department of Human Services. They'll do a search in their database to see if Mike and Mary Braddock ever received Medicaid. So Mike and Mary Braddock could have been, both have Alzheimer's and been in a facility for the last 10 years and went through all their money. And the facility agreed to keep them. And they've paid out $350,000 over their lifetime in Medicaid funds. Now, Mike and Mary never sold the house because their son Stephen was living there because he was taking care of them when they were at home. So Mike and Mary still own a house. So when Mike and Mary sell that house for $700,000, it doesn't have a mortgage, but it has the Department of Human Service lien against it. So the Department of Human Services has to be paid back $350,000 before clear title can be given to that house.
What if they owe more than it's worth?
Then the government will take all of it and say, so if the house was only worth $250,000, they would say for $250,000, we'll erase this debt.
I'm sure that this scenario, but maybe it's not in my marriage, maybe it's in the trust.
Trust.
They were both trust.
Yes, I wasn't going to go there. Then you just have to get that trust attorney involved because a trust document is nothing that you are not a lawyer. You cannot interpret a trust document. So that's where you work very closely with the attorney and let the attorney work with DHS and you figure out, so if the house went into the trust, then you have a trustee who's signing everything plus the trust attorney. So people with a lot of money will have all their assets in a trust to avoid, it's a better tax structure. There's all kind of stuff. So if you're dealing with a trust, talk to the trust attorney. Yeah. Go ahead.
The DHS letter that you're referring to,
Uh-huh.
is that only applicable in an estate transaction?
Yes, yes, only with an estate and an EIN of the estate. So those are 4 important things within a state. There's other things within a state. So you have to get, oftentimes there's inheritance taxes that need to be paid. So oftentimes when it's an estate, the estate attorney will say, okay, Mike and Mary, let's say Mike and Mary's estate wasn't in a trust. And everything they owned was worth $1 million. And their only beneficiaries were their kids. So in Pennsylvania, I think it's for kids, it's 4% inheritance tax. Somebody can Google that for me. In Pennsylvania, inheritance tax for children in Pennsylvania might be 4%. So
4.5.
4.5. So the estate would owe $45,000 in inheritance tax. The title company is going to want proof that all the inheritance tax has been paid. Otherwise, at settlement, they're going to escrow some of the proceeds from the sale of the house until the estate attorney provides the title company with a letter from the Department of Revenue saying, with regard to the Braddock estate, we are 100% clear that we've collected all the inheritance tax we need. Then you give that letter to the title company and the remaining proceeds that were held in escrow will be given back to the family. And they usually escrow 1.5 times at settlement for inheritance taxes that are due on an estate. Okay. So we've talked, do you see the importance of ownership, the importance of ownership here? How many have done estate sales?
That is sort of, the daughter and her, this living there and right?
And if you've never done one, just work closely with the estate attorney. The estate attorney certainly knows all of this stuff that you need, but it's just better that once you go through it, you keep a list of all this stuff. So that's why in my checklist, I actually have on here. If it's an estate, I need a short certificate, a death certificate, the EIN, and I have the word comfort letter. That's what we used to call it, at title companies. It was called, it's called the Department of Welfare. We don't call it the Department of Welfare anymore. We call it DHS, Department of Human Services. And instead of comfort letter, it was a letter comforting the, title company that there was no, Medicaid dollars that were owed because the people never collected Medicaid funds.
Do you know if the son is living in the house, so he has to pay them back afterwards?
Yeah.
Will they ever make him leave the house and sell it then to give them the money?
That's a good question. I don't, it's upon their death that when the house sells, they have to reimburse them. They can't make, if Mike was in the house and Mary was in the home and Mike went through all of his money, DHS is not going to make Mike sell his house to continue to pay for Mary. But when Mike dies, then he has to reimburse them. Somebody else.
Capital gains in that situation.
Well, capital gains won't apply if it was Mike and Mary's primary residence and they have a $500,000 exemption. So there could be, if they sold, well, this was the value of their estate. If their house was $1 million, they only have a $500,000 capital gain exemption. So yes, capital gains taxes could come in as well.
On the, I'm gonna use the wrong term, but on the difference then on the basis.
Well, it's on basis. So you have to look at so if Mike and Mary paid $250,000 for their house and they put $500,000 into renovations, now the basis is $750,000. They sold it for $1 million. They were married. They only have $250,000. They don't have $500,000. And you add to the basis your closing costs paid to raise it up, and you subtract from the profit your cost to sell to lower it, so that gap is less. However, the title company is going to send a letter to the IRS that says they sold their house for $1 million. They were married. That's over $500,000. Then through their tax return, they have to prove they didn't have a capital gain.
And that's going back through all the improvements.
Then they're going to have to document why they didn't have a gain on their tax return. But the title company is going to send this into the IRS as a red flag. Check the Braddock tax return to see if there was a capital gain or not.
Okay.
We're getting a lot deeper than we need to. This is all, I'm sure, like fire hose again, but this is all good stuff. And you'll just say, I know we talked about that. I'm going to call Gary when I get into the situation, and that's fine. But again, what I want you to remember, can I erase this? What I want you to remember is that deed. And let's just focus on that deed because this applies to every. Is there a better way to do this? This applies to every transaction you have.
I'll get a paper towel or something.
What's a deed tell us? We already talked about what a deed tells us. Who's the owners? What else does the deed tell us?
For the property.
Property description from the standpoint of, I don't know if that's the way they do it, meets and bounds. Better yet, property description. We refer to it as the legal description of the property, legal description. And it says you own from here to here to here to here. That's the property. It'll say starting in a southwesterly direction at this many radius, this degrees, moving forward 250 feet. Then going north 150 feet. Then going west 250 feet, then going south 150 feet. That's your legal description. That's always in the deed.
Do you have a certain app that you use? For
No. In Pennsylvania, do we have to do a survey to sell a house? No. The title company is going to plot the legal description on plotting software. And as long as it closes, that the beginning point and the ending point meet, it's insurable property. If the title company plots this and the beginning is there and the ending's there, we don't have a closed legal description. Now, the seller must provide a survey or documentation with the missing coordinate, or you can't give title insurance on that. So as long as it's not open, you don't need a survey. Now, the problem is, as an agent, do not get involved in telling people. The other thing I'm going to teach you, or when I'm teaching, I'm always going to be practicing extensive risk management. Keep your ass out of a lawsuit. And documentation is the key to keeping yourself out of a lawsuit. Documenting your conversations, tracking your emails, all that kind of stuff. If you look at my chart, I have listening notes. Every day that I do something on this file, I document what I did and what I told them and what I shared with them and what texts we exchanged and what was in those texts and what's in those emails. So it's all documented. So if I pull up this file and I go to court, that's my backup right there. Is it time consuming? Yes. It's like a doctor writing notes after a patient visit. It's a pain in the ass, but it saved me in the only lawsuit I ever had. My notes saved me.
Do you not operate out of CRM then?
I'm too old for that. Yes, you should do. That's your CRM. This is my archaic CRM. Because I intentionally don't want to have a lot of, I'm intentionally on the downside of my business, so I really pick and choose who I want to work with and what I want to do. I'd much rather, yeah. So if I do 5 transactions a year, it's fine. If I do 20, it's fine. I don't care. So yes, that's your CRM. Definitely have something to record your notes and stuff like that. Definitely. So we know it says a property description. What else does it say?
Use restrictions.
Restrictions. What else? Easements. What else? Who said it? That's what I'm looking for. First right of refusal. What's that mean?
That someone might be listed that they get to have the choice first if they want to buy it.
Right. If you don't pull the deed and you don't pay attention, and Farmer Brown always told Farmer Smith, if I were to sell my 1,000-acre farm, you have the first right to buy it. So now you can have a 2,000-acre farm because they each own 1,000 acres. So one farmer promised the other one that they would sell their farm to them first, and it's written in the deed. Now you're a new agent and you're all excited because you got this $5 million farm. And you're at the settlement table. And the settlement attorney says, Farmer Brown, agent for Farmer Brown, you got Farmer Smith's his write-off that he didn't want. It's not a write-off, a letter from him saying he is not going to act on his first right of refusal, that he's refusing his first right of refusal option, that he doesn't want that option. No, I didn't. So you run out of the settlement office, you call Farmer Brown and say, Farmer Brown, this is Meg DeReamer. And you didn't really have the money or want to buy Farmer Smith's farm or Farmer Brown's farm, right? Hell no, I'm going to buy that farm. Well, you'll be sued and probably want to shred your license at that point, but you have to pay the buyer back. What?
It's a lot of say.
No. You're not going to have a sale and you're going to have to refund the buyer. You're going to have to refund the buyer every penny he spent on that transaction. And probably the seller will sue you for not doing your due diligence up front to pull that deed. If you would have pulled the deed, you would have known this. And if you can't take care of this and remove that first right of refusal, you can't sell a house.
Does that first right of refusal stay on the deed? So in effect?
No, that's not something that the next deed has to put on, because once he buys it, that first right of refusal doesn't apply anymore. Right. The other thing that's in a deed that we have to watch for And you'll see this over in, so first of all, when a new deed is prepared, if the new owner wants something in there, a first right of refusal that his kids have the right to buy it first, he could, if the seller agrees to put that in there, then the new deed's being prepared, the new owner could put a new first right of refusal in that's, but once Farmer Brown bought Farmer Smith's farm and that was there, wouldn't need to be. But the new farmer could say, I want this to my son to have first right of refusal, my one son, because he helps me farm and I have 15 kids. So I only want one kid to have the right to buy the farm. Go ahead.
Just as an example, I live in Hummelstown, you see that out in Hershey, where the Hershey Trust has placed first right of refusal on some surrounding properties. So you go, like, I've seen it once, but it's out there.
Yes, and that's key. No, you are a realtor and you're a member of GHAR. That means you're a member of PAR. That means you're a member of NAR. Because you're a member of NAR, you have to follow what? COE. Code of Ethics. In the Code of Ethics, it says, so those are your laws, just like the state laws. You have to practice based on the Code of Ethics and you have to practice what the state says. In the Code of Ethics, it says you should not practice real estate outside your area of expertise. So if you've never sold in Hershey before and something like that came up, you would be responsible to know that. So it's very important to make sure you understand your license covers you in Pennsylvania. That doesn't mean if your friend's kid's going to school in Pittsburgh and he wants to buy a multi-unit to put his kid in one and rent the other one, that you should go to Pittsburgh and help him sell houses. What's the fastest way you make money in real estate? The fastest way, no risk. Referrals. Call somebody out there, 5-minute phone call, gave you a 25 or 30% referral and you did nothing and you have no liability. Refer business out. Don't take it on if you don't know what you're doing. What do you do if you're selling a house in Lower Paxton Township? Do you understand the Lower Paxton Township rules? When you're selling a house in Lower Paxton Township, you need 2 things at closing. What are they? Mike wants this. Hardwired smoke detector certification. That smoke detectors in the house have to be hardwired and the sump pump can't discharge into the sewer system. And you need to bring those forms to closing with you. That's if you practice in Lower Paxton Township. What about Lower Swatara? You sell a house in Lower Swatara.
Holes, the sewer system.
The sewer system, there's some pumps can't pump into the public sewer system, have to go out into the grass, and the township has to come into your house before closing and verify that. In Lower Paxton, they just have the seller sign an affidavit, a notarized affidavit. So you have to know the rules of where you're practicing. Don't take a listing in there. And if you've never sold a house there, you ask somebody in the office, hey, I've never sold a house in this area. Is there anything I need to know? Because you live there and you practice there. What do I need to know? So that's how you get. Let's say you don't expand in the areas you don't know. Just do it with guidance from somebody.
As a check hole, where would you start that process? Just calling the local township?
Township, and I call the township zoning officer and I say, I'm selling a house. Do you have any restrictions when a house is being sold? Is there anything you need to know before I can sell that house? So the zoning officer, codes enforcement officer, or somebody in the township can tell you that.
Okay, and going back to the first right of refusal, so that is that recorded onto the deed?
It's written into the deed.
Separate document?
No, it's written in the deed.
All right. I just went through there about the difference between first right of refusal and an option to purchase. They're similar but different.
Yeah.
Is an option to purchase recorded?
If it's in here, it could be a recorded document. It could be, and I don't know how you'd find that without doing a search. Well, I'll show you what I do, and it may show up if it's a separate recorded document. But here's what you do. If you're not sure, ask your seller. Have you ever placed an option to purchase or first right of refusal on your property? Ask them. And if they're unsure, maybe call a title company to do a quick title search on the property. That's your best bet. And most of you are affiliated with a title company, so have the title company do a quick search, even if it costs you $125. It's worth your time in the end. The other thing that's on a deed that's illegal, and you'll see a lot of these in Paxton Borough, Pembroke, sometimes in other things, is if it says you cannot sell this property to a person of color. That is illegal, even though it's in the deed, it can't be enforced. And then when we do the new deed, we strike that out. So there can't be illegal things in a deed that you have to adhere to. But in the 50s, that was in there, I think it's enforceable. I'm going to show you a deed. This is just quick. So in this listing here. So I was contacted by Stephen Schroeder. So Stephen is the owner based on the deed. The other thing a deed tells you, and I did put it on here, and this is huge, and I pull this all the time, is the plan. So this says all certain that tract of land with improvements, and it can be described as a lot on the plan. And it tells me the plan book and the plan page where I can find that plan. And then it gives me beginning at a point. This is the legal description, and it always says ending at the point of beginning. So this was the point of beginning. I drew all those directions in there, and I ended at the point of beginning. So I can sell that. What you never want to do is show people where you think the property lines are. You can say, well, basically maybe where they're mowing, but you can't guarantee that. If you want to know, Mr. Buyer, Miss Buyer, or Mr. and Mrs. Buyer, where your property line is, you have to have a survey. But the seller's not going to pay for it, and it's not necessary to close on the house. But if you need it, then elect the survey and the agreement of sale. And if you're competing, chances are you probably won't get the house because 99% of the other buyers aren't going to ask for a survey. So what I do to appease my buyers in that case is this deed gave me the plan. The deed also told me I'm subject to an easement.
And then I have a.
Are easements on the seller's property disclosure statement? Yes, there's a question. Are there any easements? So when you're going to your seller's house with that blank disclosure, you also print a copy of the deed and say, now, I'm sure you don't remember this or know this, but there's a question on the disclosure, are there any easements? You have to say, yes, there is an easement, and you just write what's on the deed. As per deed, there's a 20-foot wide service drive easement appearing on said subdivision plan. This deed also told me that I'm subject to covenants and restrictions and where they're found, what book and page they're found. So I know there were recorded covenants and restrictions when this house was built. So I took all those books and pages. Let's start with the first one, the plot plan, which was book 48, page 133. And here's the plan. I wanted to find the book, but there it is. See at the bottom, book 48, page 133. And it told me what lot he was. So this is the whole subdivision thing.
You represent the buyer in this scenario.
Seller. I do this whether it's my buyer or seller. I give my buyer every deed and everything on the deed, and I make them sign a receipt of documents when I do a sale. And when I go on the listing, I pull the deed and pull all of this. So I give this to both parties, whoever I represent. I do this for both parties. So the easement, is, so basically, I'm going to try to find a picture so it makes it a little bit easier. This is the easement. It's hard to read because it's so big. So this is White Birch Lane. This is the townhouse. These are the garages behind the townhouse. It's kind of like Kensington Square, Devonshire Square. And then off of the main road, there's an easement to get to all these garages. Behind the garages, then you go through the garage, into the courtyard, into the house. So pretty straightforward. But here's the reason why I wanted you to make sure you always pull the plan that's mentioned in the deed. Thanks.
Yep. All of it.
Yeah, your buyer told you, Mike, I'm looking for a property where the house has to be decent, but I want land in the back of the property to put in my in-ground pool. I want to do this really high-end kitchen, outdoor kitchen, a nice fire pit area. Beside the pool, I want a sauna, a hot tub with the water flow into the pool. So I'm going to drop about $400,000 into the backyard, but I need to. So if this room is the lot, I only want my house to go to here, and I want all that land back there. If it's treed, I don't care, I can clear it. I just want that land back there to put in my dream exterior living situation. You pulled the deed, you didn't pull the deed. And you didn't pull the plan. But at settlement, the title attorney is going to show them, by the way, here's your lot. And it's going to show their lot. Based on the deed. And it's also going to show the 50-foot sewer easement that ran right through the middle of the lot. So all the public sewer runs right through. Can he build his dream kitchen? Now, he sues you. Now you're in court. And the prosecuting attorney says, I'm going to pick on Maggie because Maggie knows to do this. Maggie, isn't it true this plan was on public records? Yes, Your Honor, it's true. And isn't it true you could have pulled that? Yes. And isn't it true if you would have pulled it, your buyer wouldn't have bought the property? Yes. And you didn't pull it, why? What's your excuse? You have no defense. It was out there, you didn't pull it, you knew it was important to your buyer, you could have prevented all of this. You were just too lazy, you wanted to make a buck, filled out paperwork, and you went forward. Now, you could say, well, it wasn't on the seller's property disclosure. Well, the seller didn't know. Are you aware? The seller was not aware. But the agents could have found out. Now you could say, why didn't the listing agent pull this? Well, he's as lazy as you. You didn't pull anything. So you're both lazy. Right? I'm being a little bit dramatic, but this is why you pull all this stuff. So you can help the seller fill out the disclosure correctly. Because isn't there a question on the disclosure 22A1A? Are there any deed restrictions? Most sellers say no because they think, am I restricted on using my property? They don't understand that a deed restriction is anything mentioned in that deed that says there's restrictions. This deed says I have restrictions. This property is under and subject to restrictions. So what I have them write on that line is as per deed, restrictions in miscellaneous book 345, page 41. Now, I have those printed. So once you print all that stuff and you go into Bright, you put all that stuff under associated documents. So that now the buyer's agent has all this information. So there's no confusion when the buyer buys the house. He has everything he or she needs that's out there. So all of that stuff as the listing agent, you want to make sure you put in Bright. So when you look at that house and you pull up associated documents, is that the right one?
No, it's the right, yeah, there you
There it is, the deed, the disclosure, the items to convey, the plan, the original declaration. Before I list anything in a townhouse or a homeowners association, I call the HOA. I say, send me the documents, please. Sometimes you have to go through condo cert and all that stuff. But there's a management company that will give you want to confirm the fee, because that's in the disclosure, and you want to confirm the capital contribution amount, because that's in the disclosure. And you want to have all that section of the disclosure filled out accordingly. So when I call, I found these online. They didn't have them at their association, so they gave me what they did in 2025. They did an amendment. There was assessments and fees addendum, and they have a non-owner occupied property. Isn't that important when you're selling a townhouse? Can I rent this townhouse? Well, this association has a non-owner occupied properties addendum, which dictates that. That's something I want a buyer to know. I don't want an investor wasting time setting up a showing on my property if they can't rent it. So I asked the association those questions. So all those documents are out there, and yes, make them public. Why don't you make them public? You make all that stuff public. So getting back to the disclosure statement. Where it says the condominium, here's everything they need to know. Contact Beverly Miller if you have any questions. Because if the buyer wants to know about the association, I tell the buyer and their agents to call Beth Miller. Here's her number. Here's what you need to know. It's a monthly fee of $85, and you're going to pay $1,020 at closing. Why does the buyer's agent need to know this? He's doing a buyer's estimated cost sheet. That goes on the buyer's estimated cost sheet. So it's all there. Remember I told you about easements? See here, boundaries. As per deed, property is subject to a 20-foot wide service drive. There's a shared alley to access the detached garage, and it's part of the HOA. That was on the deed, therefore it's on the disclosure. The last thing I showed you was there were restrictions, covenants and restrictions. It clearly says 22A1. Are there any deed restrictions or restricted covenants that apply to this property? Yes. You have to explain your yes answers on the next page. The yes is 22A1, as per deed, declaration of protected covenants, restrictions, and reservations, miscellaneous book, page 45, 345, page 41, and the instrument number. So if they want to look it up by instrument number. Now, people say, how do you find this? Unfortunately, in Cumberland County, if you're selling in Cumberland County, you have to buy a subscription to, you have to have Landex. Landex is a free software you download to your computer, but you pay for the time you spend in it. So,
Or per document.
well, yeah, so once you're in Landex and you load a document and you print it to PDF, you pay 10 cents per page. And when you get out, it tells you what your balance is left. So you have to preload the software for the counties you want. Like I usually load 50 or 75 bucks in the county. And then as you use the county, you pulling stuff off the county website, it defines your balance. Dauphin County is free. That's the beauty about Dauphin County. The Dauphin County is free.
Here, I have a question.
Sure.
So,
Go ahead.
For like a really old property, like I'm getting ready to list. And it mentions 2 prior deeds that were recorded and it gives the deed book and page number.
Yeah.
Do I need to pull those too, or would any restrictions and easements automatically carry over?
What often happens is like the original deed listed all the restrictions. The next deed says it's subject to the restrictions noted in deed page 2, book 2, page 3. Then you got to go to that to see what the restrictions were. So you have to figure out so oftentimes I go back and have to pull more deeds. But somebody was saying like what's reported under a person, what if they had a first right of refusal or an option to purchase under a person's name? So sometimes if I'm not sure or they're not sure, I just type in the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just to type in Muccio Gary and hit search here, it will give me the person's name. So if I were just on Landex.
Sure. Yeah, that situation, I know exactly what you're talking about. You've read the same original deed and I know.
Yeah.
There's everything that's in the courthouse recorded under my name. So for mortgages, so this is what you want to do. You want to look at the instrument type. So that's a deed, a mortgage, an assignment of mortgage, another deed, sub mortgage, satisfaction pieces. I go to the extent, and this is a little bit overkill, I print it. And then I make sure that every satisfaction piece references a mortgage. So for example, this satisfaction piece satisfied the mortgage that was recorded in 1733-2355. So this satisfaction piece satisfied that mortgage, and I cross them both off. And what I'm looking for in the end, are there any open mortgages that haven't been satisfied? So that when I go on my listing appointment, I say, Ms. Brown, Rebecca, is there anything, do you have an open mortgage? No, I don't. Well, yes, you do. Here it is. And it's a home equity line of credit. But I have no balance on that. So in her mind, she thinks I owe nothing, but she has an open line of credit for $150,000. So there's a $150,000 lien against your house, even though you owe zero. So what will happen at settlement, that home equity line of credit just gets closed. But the problem is, if it's somebody's lived in their house for 40 years and they use like savings and loan associations from the 1980s when they were being sold, some of you aren't old enough to know, but that doesn't mean you can't be in a situation where you're selling a house that was subject to all this. There's a bunch, I just did an estate in Camp Hill that was financed through savings and loan, and there was no satisfaction piece for First United Savings and Loan that closed 1,900 years ago. But the title company said, we know this is satisfied because you couldn't trace it. And apparently they were able to find that the mortgage was stamped satisfied. So it's just, you're going to come up with this kind of stuff at settlement. So I just try, my settlements are flawless. I go to settlement and sign papers, we're done. I never, ever have an issue at settlement by design. Because I check all this stuff out ahead of time. I ask my sellers, do you have mortgages on the house? I'm showing that you have two. Yes, we have our primary mortgage and we have a line of credit. Great. I collect that information. I'll show you the forms you fill out. But search and accounting records. The last thing I do before I go on an appointment is ever talk about myself. I just go with a ton of information and I usually get the listing because they say to me, well, we interviewed 3 other people and they didn't bring any of this information. And I just say, I never say who, I can't ask who they're listing with. I just say, well, I'm not sure why they didn't do that. It's all available on public information. It's all public record. All this is public record. And we need this information to be able to sell your house because it's all going to come up later. So that's the background information I do before I go on a listing appointment. How many of you would say you do at least 50% of that? What have I told you that you don't do that you think you'd change and do moving forward?
I think we start looking for restrictions and easements and other actually putting in this.
Okay, that's excellent. Because the disclosures, what we're going to go over also. You have a question?
I've seen this a lot in speaking with agents with sellers disclosures is that their sellers are filling out like checking yes boxes on the seller's disclosure, but they're not doing explanations. And this agent is not going back and asking your seller to clarify that. I've seen that a lot lately. And then also what they're listing on Bright as far as utilities and things like that are not matching what's on the seller's disclosure. So I guess as a list agent, we just can't take the seller's disclosure at face value. We need to be reviewing them.
It's the responsibility of the list agent to make sure the disclosure is filled out properly and to the best of the, you never touch it, you don't fill it out. But I spend on average a minimum of 2 to 3 hours with every seller on their disclosure. It might be 2 appointments. So I bring it over the first time and I say, here's a draft, give it a shot. Then we have just a disclosure meeting, whether it's over the phone, Zoom, whatever. just to review that disclosure. Because I remind them about things on that disclosure that they may not know. So if we're talking about that, let's just look at it. Most sections are pretty easy. You know, this is common sense. I tell them, even if you're the owner and you're not these, make sure every block is checked. Why do with pets on here, people have allergies? So they said no. I said, so when I see no, I say, so you've never had a pet in the house? Oh yeah, I had a dog when I first moved in, but it died after the first year. Okay, you gotta put you on a dog. Have any animals lived in the house? That's the question. So most listing agents drop it off, pick it up, scan it, and put it on Drive. You are liable as a listing agent if it's incorrect. You're liable as the buyer's agent selling that property with an incorrect disclosure if you don't ask the listing agent to get it updated. So the reality happens though is when you're in a multiple offer situation, if you're the pain in the ass buyer's agent wanting that disclosure filled out every inch of its life, and the 4 other agents you're competing with accepted it as is, your buyer probably won't get the property because you're annoying, but it doesn't matter. If your buyer wants you to get those answers and they lose the house, what if those answers were important and they were wrong? And now your buyer's stuck with a cost. And they ask you to do it and you talk them out of it because they'll lose the house. So that's the problem, because the listing agent doesn't want to be bothered to go back to the seller to get it filled out. So I always tell my sellers too when I drop this off. So if I know it's in a condominium, I get the contacts of the association and I call to make sure that this information is correct. So if it's PMI, I call the person at PMI, I say, what's your capital contribution fee? Just confirming my seller said it's $85 a month. Is that true? And by the way, can you send me the documents? Now, most companies won't send you the document. They want you to pay $400 and go on that condo doc. Yeah, so you have to do that. You can be reimbursed for that at some. When I give them the disclosure, I give them the past disclosure, the most recent one that they got when they bought the house. And I tell them, if you're using information on that, write where it came from. For example, on this house, the seller said the roof was replaced in 2012. We don't know that other than the prior owner told us that. So we put 2012 per prior owner. So any information they're taking from the prior disclosure on when the furnace was done, the roof was done, if they never cleaned the furnace and the last time it was cleaned was per the prior owner, then you write the words per prior owner, because it's not what you know, it's what what the prior owner told you. Think about it. As a buyer's agent, when you sell 123 Main Street, whether I'm listing 123 Main Street or I'm selling 123 Main Street, I'm going to go back and pull the old disclosures. One, for my buyer to know what the prior owner knew, as well as what the current owner knew. And if the house was listed every year for the past 4 years, I give my buyers 4 years worth of disclosure statements because it's out there. It gleans information. And then I make them sign a receipt of documents that I gave them, disclosures from 2014, 15, 16, and 17. That's on a receipt of documents to cover me, that they knew more information about that house than just the current disclosure. They had the old ones.
The reference to the receipt of documents, you do that for each time? You do it
Yes.
and signing off or checking that you've received all these?
Everything I give them when we're signing the sale paperwork, I have at the bottom. The receipt of documents has another section at the bottom. And here's what's always on my receipt of documents as a buyer's agent. They got a copy of the multi-list printout. They got the multi-list tax record. They got the deed. They got the plot plan. They got anything I found on county records. And if there were 4 past disclosures, I make them acknowledge those disclosures. And then they sign 1 receipt of documents and I hand them all those documents. But at least I have records that they got them. And if it's in an association, then we do another receipt of documents when we give them the resale certificate and the HOA documents.
Would you be able to share what that looks like? I mean, I didn't know if there's some language or wording at the bottom.
I'm trying to think what buyer I have thinking. I'll think about it. I have tons of them out there somewhere, but I can show you.
Just gonna say, can you just say that list one more time? I got most of it.
So you want your buyer to acknowledge the a printout of the MLS if it was listed. A printout of the MLS tax record. Why do we give him the tax record? Because it shows square footage, it shows taxes, it shows what the property is assessed at to calculate taxes. And the deed, the plot plan, if there is one. Anything that's recorded on the deed. And then any prior disclosure statements.
Thank you. When you're taking a buyer to look at something, do you pull the land ex mortgage things on?
No. No. I mean, if you're trying to negotiate, it might be helpful to know if the buyer, that the seller's house is satisfied and they have no debt. Would that be helpful in negotiations? Maybe, but that doesn't mean they're going to take less just because the house is paid off.
Well, if we had a situation on a rental property where we had an accepted offer, the listing agent didn't realize they were upside down.
Oh, that's a different story.
So, we were like, well, we're not gonna pay the $12,000 debt that you owe. They needed to then sell it for more to actually cover their thing. So, like, as the buyer, is there any benefit to that? Like,
There could be in that situation.
I mean,
The problem is with pulling up the mortgage that I showed you, it's gonna show what their total mortgage was when they bought the house. So if it's 12 years now, I guess you could do an amortization chart and see where they are, but you have no idea what their balance is.
but would it show you if they refinanced or?
If they refinanced, yeah.
Better
If you-
thing, because that's what had happened.
Yeah, if there's 3 mortgages out there for $1 million and they're selling the house at $250, where are the balances on these mortgages? Yeah.
And what about like a tax sale kind of property where you don't know any details on that? Do you know what I mean for those?
I never did a tax sale that I can, so in my career, I've never done a tax sale, and I can honestly say I've only done one short sale, because I just refer it out. I don't do those.
Okay.
So if anybody Mike, do you ever do tax sales?
No.
Okay. It's a whole different avenue or ballgame. You're doing your buyer a favor if you say, look, I'm gonna refer you to somebody else because I don't do this. Really, keep yourself up. So I always tell my sellers, there's 2 types of questions on here. Are you aware? And when it's an are you aware question, it's only a yes or no answer. You're either aware or you're not aware, period. The other type of question is, are there any? And I guarantee you, most of you are looking at this different. And it's under sewage. The house is in a development. It has public sewer. Let's think of this property here. This is a lot in a development with public sewer. Because the multi list says public sewer. Even if you didn't pull up the description and see the stories and through it, the MLS says public sewer. Sewer. Say that. That's my my Northwest accent coming through there. Public sewage. It was built in 2015. When your seller's answering the question, are there any metal tanks, concrete tanks, fiberglass tanks, any other type of tanks on the property, what are they going to check? No. Then I say to them when I'm looking at their disclosure, when did you dig up your yard? What the hell are you talking about? I never dug up my yard. Well, then how do you know if there are any metal, concrete, fiberglass tanks in your backyard? It says, are there any? And you have the option of saying, I don't know. Why did you say no? Because now you said no. And this particular lot in the whole subdivision is where the original farmhouse sat. So now the public sewer easement is out in the street. So your buyer who wants to do his nice outdoor area can do it, except he starts digging for the pool and he uncovers 10 cisterns. So now those can be removed, but his excavation cost just went from $5,000 to $10,000. And that buyer of yours relied on the seller saying there were no tenants. Guess what? Your seller is gonna be sued to pay the additional excavation costs to put that pool in. Because he had the option of saying he didn't know. And he said no. And you should be advising them accordingly, how they're answering the question. Again, are you aware, yes or no? Plumbing's important because we have lawsuits on polybutylene. I tell them, only put down the plumbing you're aware of 100%. If you look under the sink and see copper supply lines and white PVC piping, then put copper and PVC. Everything else unknown. It's up to the buyer if they want to have a home inspection. But you don't know because you're not a plumbing expert. These are just some of the things that are gonna, but what's a real estate lawsuit always about? Two things. Seller misrepresentation and seller non-disclosure. They didn't disclose the material defect or they misrepresented the state of the property. And what's the first document the attorneys are gonna go after? Right here. This is your most legal document. Keep you protected. So that's why I spent so much time on this and make sure it's explained very clearly. In this house, it has an awning. They've used it once and it worked. So they're saying the awning works, but it's used infrequently. And it worked when they last used it. That's what we know. They have a pocket door in the primary bedroom that you have to kind of jimmy to pull it shut. So it's off the track, but it still closes. Well, I don't want the buyer to find that out during an inspection. We're gonna let them know that right here. Is it a material defect? Not really. Does it affect the value of the house? No. Does it affect the safety of the occupants there? No. But isn't it nice to know? Think of a situation where you're in the basement during a home inspection and there's a stain in the ceiling tile and that stain is dry. The home inspector put his moisture meter on that stain and it's dry. And the buyer's agent calls me and says, hey, Muccio, there's a stain tile here, it's dry. Can you tell us what happened? So I call my seller because I'm a sloppy agent and I didn't look at that when I did my preview of the listing and I'm sloppy and I didn't review their disclosure and I didn't know what they put on there. They said, oh yeah, the sink drain leaked and we replaced it. So problem solved. Does that have to be disclosed? Not really. But if you're going to fix it, change the tile out. So now you're putting suspicion in the buyer's mind. Okay, that happened and they didn't disclose it. What else weren't they telling us? Buyers are super suspicious that sellers are lying to them anyway. So just disclose everything, tell the story, tell the current state. And now think of the opposite of that. So the home inspector says, I wonder what happened here. The buyer says, oh, it was noted on the seller's property disclosure statement that they had a leak in the sink trap and they replaced it. They just didn't replace the tile. So the home inspector would say, okay, that is correct. This is dry. The problem was fixed. Now, isn't that a whole different story than calling and asking what happened? So it's all psychology with buyers and sellers. So this form is just to cover your ass, CYA. Make sure it's correct, look over it. And like I said, spend the time on this. Talk about easements that were written on the deed, restrictions that were written on the deed. So enough about that. Let's take a break for about 15 minutes and then we'll go on to the listing contract. And then do you have that?
I was gonna say, these are all the contracts,
Okay.
and these are extra copies of.
Okay.
All those
That
papers.
guide to the agreement that I sent you.
Yeah,
yesterday. Oh,
did I hand that to you? I printed it, but if you want,
Here.
cool.
Awesome. So hey, Gary. Hey, Gary.
What?
A quick question. I feel so something right now.
One.
My previous marriage, it's only a term. It's not a sense. Sellers not really helping us.
You don't ever touch it, you don't ever break it, but you can guide them on what to make sure it's correct and accurate and ask questions. Absolutely, absolutely. You
I
don't,
thought you were kind of.
you're responsible to make sure it's filled out correctly and accurately. And if they're telling you something, regardless of who you represent, the state law requires you to disclose the defects, even if they don't want to. You like.
But even if I don't know them,
So if you drop.
like if they don't tell me.
You still have,
Like,
you still have to make sure that you're guiding them through the transaction. When they have a question, how to answer that question, you can give them guidance to tell the whole story. You don't write it down, you don't touch the disclosure. But you still make sure that they're right, they're documenting. How many people help their seller fill out the disclosure as far as guidance? I mean,
Exhausting.
it's exhausting. It's exhausting, yeah. It is exhausting. I agree. It takes a lot of time, but you review it before you scan it and upload it, don't you?
Yes. Yeah.
I try not to sit there in the initial part, I let them fill it out and fail.
Yeah, fill it out and fail and then correct, yes, because then one thing that does is shows your expertise and the value of why they're hiring. Yeah, I give it to them and I say, circle the line number of where you have a question. Now, when I come back, we'll talk about it. You know what I mean? Yeah. So this way,
Thank you.
is this everything you have too, or?
Those were, I have, it's all 7 papers that you sent me.
Okay, so that's what this is too?
Yep. Yeah, I just printed more just in case that was needed.
Okay.
And I told them I'll also email them a copy of all these papers as well,
Okay,
just so that they have it.
Yeah.
And these are they can fill them in
yeah, as we're talking.
as PDFs. Yeah. So, yes.
Is there a limit of years that somebody go back to a seller and sue? Is there like?
Yeah.
I don't know.
Okay.
I don't know.
I'm just curious.
We have this very thing with the water meeting. I don't know, it's a lot, but it's like, oh, there's water. And then like, you might not be able to- Yes. And they-
Yes. They did buy a lot.
And they even had room for the plants for where they're like, they realized we don't want our plants in your maybe tell you that there's a problem, like the water meeting.
Yeah, that's it.
Like, so.
You can enjoy the land over an easement. And if you build something on it, they can tear it down and they don't have to replace it. Now, the township wouldn't let you put something over an easement knowingly. But if you do, and they have to tear it down to get access, they don't have to reimburse you for that.
Yeah.
So,
You have copies of the listing contract. Any chance I'm getting that, so.
I didn't know if people were gonna look on there or not.
Yeah.
I was just gonna look at it online, so.
Okay.
She just. Okay, so she's posting.
Gary, Ed wanted to know where does being sold as is noted by the seller?
Hmm?
Where does being sold as is, where would that be noted by the seller?
That,
It depends what they're talking about being sold as is. We can talk about that when I get back. Remind
Got
me.
it. Yeah.
Our listing contracts, our sales agreement says the home is being sold in as is condition as the buyer saw it. So
Okay.
that doesn't mean the buyer can't have inspections, but as is already printed in the sales contract.
Okay.
Yeah. So that's taken. Each of my oh my, so here can she hold under? Okay. However. It's changes. This one. And this is the age. Yeah. Just speaking. Yeah. Oh my goodness, because then yeah, maybe I choose, yeah, no, but it changes, but needed to be signed. And when I was actually a start, brings to the state. So that's what I got, I just do. Yes. What? Yes. Yeah, I'm getting no. Yeah. Yeah. I was like, no, for you. What? Just uses the same. Yeah, yeah. He said he's good. It's up to the buyer to do something, right? It's not. It's just saying, it's just yeah, just feels very fishy. Yes. And I think it just leaves you very interesting. And then they're being missing something. Zero. And then we're gonna by charging them more. Let's get the range. Where they need to choose. Just this. Just this. Is using search choice to. So then you use that English that can only talk to them. Just I would say that's just like file into the yeah. So so how do I know it's copy now? Wouldn't have even known. I would have swooped in. Yeah. Yeah. Client was taking it. I was like, because I'm not just. And so they should be with a letter stated. And that's the. And then yes, they do it's the right to be. Yeah. So it can help, but yeah, that's and then go to avoid this. And she I want so this is just this she has that. Actually, at stage, I can see one under the experience of the same one. How does that happen?
Oh, she was.
As if I.
Yeah.
It's much.
Yeah. Absolutely. Yes, yes, yes. Fine. Yeah, yeah, it's even like these and stuff.
Yeah.
Oh, yeah, it's a big issue. Yeah, it's not at all. Did I get that up? So let's pick up real quick, look at that listing checklist. I just want to show you a couple of things. So basically, we talked about creating your own file on your drive, creating a file in command, looking at the deed, the plot plan, covenants and restrictions. I wrote in there smaller text. I look up to see if they have a mortgage or home or a HELOC. I check right for prior sales activity and SPDs. I always pull the right tax record. The other thing we should do is we should know how to calculate taxes on the property. So I'll show you that real quickly when we start again. The +4, you don't have to look that up. There was a time when we were, there was a big push with the post office to go to a 9-digit. Your +4 is on your right tax record. I just confirmed that it's right. So you can go to USPS.com and do zip code lookup. Complete your CMA and make sure you're doing Act 112 disclosure under CMA. If it's in the state, make sure you have the short certificate, the death certificates, the EIN, the comfort letter. If you want to, if you're working in a rural area, there used to be a website for, and this is dated, I will tell you, make sure you check that. There's a site where you can determine if a condo is FHA or VA approved. So talk to your local lender about getting those updated sites. So if you want to advertise a townhouse or a condo as FHA or VA approved, yeah, there's sites for that. And then if you're in an urban area, USDA would offer 100% financing. So that's just an added advantage to your house. So if you're working in rural areas, the USDA site would say if the home qualifies for 100% financing. So that's just when you're advertising the property. Then the next are all the zip forms that we use to do a listing. But before we go there, there's two things I want to say because I feel badly. What's your first name?
Kara.
Kara was a little bit anxious because her prior broker told her never touch the seller, don't help the seller fill out the disclosure form. You should never write on the disclosure form as the agent. You don't fill it out for them. You're guiding them through how to think through the process and talking to them about their house and what they've done and problems they could have had. I've owned my house now for 28 years. I can't remember all the stuff I've done. I mean, I keep a file of every time I do something major or I have a problem. I have a house receipts file and a home improvements file for my house. And when I fill out my disclosure, that's what I'm going to reference. So you're not filling it out for them, you're guiding them through. And just remember, I'm giving you 150% of everything you should possibly do to try to eliminate any kind of liability. But the bottom line is, every transaction goes to closing, and there's probably a 10% error rate in something that happened in the transaction. But by the grace of God, it closes and you get your paycheck and you're done. Happy people don't sue. If your client is happy and you show them you've done a good job, they're probably not going to sue. The problem is when there is a lawsuit, attorneys are going to do what's called a broad sweep, and they're bringing everybody in. Even if you're the buyer's agent and did nothing wrong and the seller was lying on the disclosure, you're brought in. Because why? Realtors have what? They think we have deep pockets and our money, we have a lot of money. And we have what's called errors and omissions insurance. And they know if they sue us for a certain amount, and if that's the amount of our deductible, we're probably just going to pay versus going through a lawsuit. So you just have to protect yourself. That's all I'm saying. So don't feel like you're doing something wrong. If you can pick up a good tip and weed it and incorporate it into your listing process, that's all I'm trying to accomplish today. I forget your name in the back. Tony. You asked me for a copy of what I give my buyers. This was a recent buyer. And this is a receipt of documents form. So the very bottom of the receipt of documents form. So we use the receipt of documents form, and this isn't a purchase class, this is a listing class. But you would use it if you sell a condominium or a homeowners association. We have a state law that says a buyer can back out of the contract at any time. Any time. And for 5 days after, they receive the association documents. So as a buyer's agent or a listing agent, if you're in an association, get those documents to the buyer and make them sign and receive the documents because it's a loophole. A buyer can terminate until they get these documents and for 5 days thereafter or settlement, whichever is sooner. And we have to give them their money back. So think of a situation where you've had a $2 million listing on the market for 5 years and it finally sold. And there's the buyer put down $100,000 deposit. And you're the buyer's agent 2 days before closing. And he calls you and says, oh, by the way, I'm terminating my agreement and I want my $100,000 back. Well, you can't. We're going to closing in 2 days. All the inspections are done. We're ready to go. Oh, no. This is an association and I never received the documents. And I got a job offer in California to triple my salary. I'm leaving and I'm getting my $100,000 back. So chances are your seller's going to sue you because you didn't close that loophole in the agreement to get the buyer this done. So we need it for condos and homeowners associations. Here again, if you've never sold an investment property, partner with someone who has. Don't take on an investor client and you've never sold investment properties. Because if you sell an investment property, the buyer has to acknowledge receipt of the current leases. What do we know about leases and investment properties? What can't the buyer do when he buys them? So we have a 5-unit apartment building and the rents are only $100 a month and they could be $1,000 a month. And the investor sees that potential and he buys it. What's he buying? Leases. He's buying leases. And if these leases are for 1 year, he cannot change those rents for 1 year. So if he assumed he was buying it and going in and changing them in 30 days, can't happen. So you need proof that you gave him the leases and he acknowledged them. And then there's a tenant occupied property addendum to the agreement of sale, which says he'll get the leases in 5 days and have 5 days to determine if he wants to buy them. You can change the number of days. But how do you prove you gave the buyer the leases? You use the receipt of documents form to show that you gave the buyer the leases. And then there's another section. Buyer acknowledges the receipt of what? And here I have the bright MLS, and I put the MLS number, I put how many pages, the bright tax record, copy of the deed, where it is, the plan, the protective covenants and restrictions. Prior seller property disclosure statements dated, and I used the date that the seller signed those disclosures and how many pages they were. Because I found one from 2009 when we only had a 6-page disclosure. So that there's no way they can say, I clearly described what I gave them. Does that make sense? Does everybody see the value and benefit of giving? If you've done the research, make your client acknowledge that they've received it.
I do something in between where in document, I have them initial
those documents.
NLS, the public records, everything like that, but
I used to do that, but this is just easier.
yes,
Now they only sign one page and it's documented here what we gave them.
yeah. So is that an R form then?
Yeah. Mm-hmm. RUD. Right there. Okay, so now we'll start with the actual physical documents we prepare when we do a listing. So the first thing, I don't think I have to go over what a consumer notice is. You should all know what a consumer notice is. Then the listing contract and single agency addendum. I really want to focus on the single agency addendum. I'm just going to use one of my transactions. I keep looking up there and I realize I can just look. How's wrong with you? Does anybody know what a single agency addendum is, other than maybe Maggie? I say Maggie because Maggie, I work with Maggie, we work together, so we're not a team. She just is my right hand.
I'll take a stab at it. Isn't it that if you sign a listing contract, the brokerage is technically appointing everyone here, not a specific individual?
Close. So let's go over, let's do a quick agency class here. If you get a call from somebody who wants to buy a house and they come in and meet with you and they like you and they ask you questions and you answer them all correctly and they want to work with you, and you give them what? First of all, you give them a consumer notice that explains all the agency rules. Then if they say, okay, Adrian, I want to work with you. So you sign them up with a buyer's agency agreement. And that has a specific amount of time and what your fee is. And what does the buyer's agency agreement says? Who pays the buyer's agent in the buyer's agency form? The buyer. It is always said, you hire me, you pay me. And you're thinking, well, that's not true. The seller pays me. No. The form says buyer will pay broker and what the fee is. It goes on to say that if we sell you a home where the seller is willing to pay something, we'll take that to offset what I want, but you're entitled to pay me. If the seller won't pay me anything and you want to buy the house, you have to pay me. Now, with that said, I want to sidetrack one thing because I don't think we're doing this because of the lawsuit that happened. We're forgetting to do this. So this is just a sales tidbit. When you're doing your buyer's estimated cost sheet, you should have a line on there that says broker fee, broker commission. So if you're selling them a $200,000 house and your commission to sell that house is 10%. Your buyer's agency said they paid you 10% and they're buying a $200,000 house. You better have a cost on their buyer's estimated cost sheet of $20,000, which is your commission. Now, because isn't that a cost to buy the house? Now, you can say, something, use different words, but the bottom line, fee from seller, because when you showed the house, you called the listing agent and the listing agent said to you, I'm willing to offer co-broke 8% if you sell that house. So now they have a $16,000 credit. But they still owe you, if you're gonna not change your buyer's agency agreement, they still owe you $4,000. Is that a cost for them to get it in the house? Are you putting it on their cost sheet? We haven't done this in the past. It's not how, because we always had co-op broker compensation. And it was in the multis, and we knew what we were getting paid. And most of the time it was enough to cover our buyer's agency agreement, so we didn't have to do this. But moving forward, when you do a buyer's estimated cost sheet on a sale, you better have 2 lines on it. In the state real estate commission rules and regulations, if they audit your file and you don't have a buyer's cost sheet prepared by you, not the lender, you, in your file, you could lose your license. Now, they wouldn't fine you and take your license away probably on the first offense. Yes, you get the lender's cost sheet. You definitely get a lender's cost sheet because there's all kind of fees on this that are lender related. So you need to know what the lender's going to charge them. What's the lender's appraisal fee? What's the documentation prep fee? What's the loan origination fee? You don't know that. So you need the lender's sheet to fill out your sheet. And you can have them sign both. I have them sign the lender's and I have them sign mine. But the state's looking for the one that you, the agent, prepared, not the lender's one signed. A signed lender's cost sheet will not pass an audit with the real estate commission. Has to be yours.
That technically needs to be done behind the law.
Yes. Yes. And by that time, if the seller said they're giving nothing, and you're putting in the agreement of sale 8, it's okay to do this. But if when it's all said and done, the seller only gave 5, you got to come back and redo this. So now they know you have to do another cost sheet after the agreement of sale is executed with what the reality of that transaction is to your buyer. Just as when you do a seller's cost sheet after when there's a sale, and then we have home inspections, and the seller agreed to give a $5,000 credit towards repairs, you got to do a new cost sheet during those inspection negotiations as well as listing agent. Okay, so
Something simple as have settlement dates being moved. I mean, you have to do it at the time the settlement dates moved and the taxes change just slightly.
I don't do when it's a couple of days of settlement. I don't. Technically, you should, but I don't. I mean, I tell my seller, because we're moving it, settlements delayed, you're gonna get a little bit less because of tax prorations. And if they say, well, how much less, then I do. But if they say, yeah, we're not worried about that, I don't. And that's where theory, yes, you should do it. Reality, we don't. Everybody's happy. It goes to settlement. So you can't always be hardcore to the book. But when it's huge costs like this, right, you absolutely have to.
Workarounds for lenders that don't give cost estimates before going under contract. And it's somebody they want to work with, they've worked with before. How do you?
I would just use averages that you know and go, you know that the cost of an appraisal is $650, I'd maybe put 800 in. You know that loan origination might be 1,000, I'd put maybe 1,300. You know what title insurance costs. You know, I would put in there an underwriting fee, perhaps. Anything, look at Bright and see what the numbers, what the questions are, the costs are, and I'd throw numbers in there and I'd say without your lender. You know, the buyer should have those from the lender. And I push it back on the buyer. If you're using that lender and they won't talk to me, here's the fees I know. And I would write on their cost sheet, plus any additional fees charged by the lender who would not disclose at the time of this cost sheet. So I wouldn't even estimate. I would just put what you know, you can figure out title insurance, transfer tax, tax prorations. So
Just outright refuse to give you numbers? Yeah, they'll give a pre-approval, but they won't give cost estimates until you're under contract. Interesting.
I've had them say, we don't generally do that. Then I'll get my buyer's estimated cost sheet and I'll ask them, what do you charge this? What do you charge, line item by line, which is a pain, but I've never let them.
Your local ones tend to be better, your local lenders, some of these online ones that are,
They're the ones who do.
yeah.
but here's the thing, real estate's all about partnerships and you should be working with lenders that you know. Now you can't steer a buyer to a lender. So you give them a list and you say, these are 3 lenders that I have great experience with. And you could prioritize those lenders from 1 to 3 with who you want them to call first. But you have to give them choices and options. And you can say why you recommend that lender. And one thing, I've been a PSECU member for 40 years. I would never go to PSECU for a mortgage. And why? Because their pre-approval letter clearly states they are not responsible to meet the mortgage commitment date. That's agreed upon between the buyer and seller. So I tell my buyers, If you wanna go with PCCU, that's fine. But if they don't meet the mortgage commitment date, and I shown in the contract where it says, if the seller doesn't get the commitment letter by that date, they can terminate this agreement. Do you want the house guaranteed, or do you wanna run the risk that the seller can terminate? You decide if it's stick with PCCU. And I just had a pretty heated conversation with the PCCU loan rep. He said, why don't we use this? I said, because you won't commit to the commitment. Well, we never missed the commitment date, but you don't have that new letter. And I said in the contract, I said, I'm gonna send you this page while we're on the phone, so stay with it. And I printed one page PDF, emailed it to him, and I said, right here, what does it say? Seller can terminate. I'm not putting my buyers at risk of terminating. I worked too damn hard to get this deal. And I'm not letting you guys ruin it for me. Well, it says if the seller, we don't have this, but the seller can terminate. I don't control the seller. I have to buy. Oh, maybe I'll bring this up to my senior leadership. Well, it's been brought up to your senior leadership a million times. I don't know if you were in the business, but years ago, they solicited a bunch of realtors to come in and talk to them about how they might be able to do mortgages better. And our biggest complaint was they won't honor it. They meet the commitment date. Huh?
Based off the mortgages.
Yes, HELOCs, car loans, yes, they're too risk adverse to do mortgages, I think. You know, and maybe they have to follow, I'm not here to bash PSECU, so if you have, if your parents are on the board of PSECU, I'm a member. They have a lot of my money. Yeah, I don't use, you remember, you don't use it for mortgage stuff.
So just recently, I've had an experience where, I think I might mispronounce it, Penny Bank. I work with them where they provide me call sheets, and then I'm working with the same lender, different contact person. They refuse to talk to me about anything while I'm representing the buyer. They didn't give me their estimated cost sheet. They wouldn't tell me where they're at in the process of it.
That's fine. I'll go with another letter that provides underwriting approval beforehand. We want you guys go back on that.
Well, throw it back on your buyer, because you have to go with who the buyer is and just say, because you use them, my services to help you are extremely limited. So if this blows up, and you can invoke a little bit of fear in your buyer, because you have no idea if it'll blow up. It could easily blow up. And I would push it back on the buyer that they made the choice to use Penny, not you. So I would push it back on the buyer to say, if you want to use them, these are the risks you take.
It ultimately did end up blowing up because of that gap in the communication. We ended up getting pretty far down the road where she was assuming that all the buyer agent fee was being paid for by the seller. On my cost sheet, I did have the broker fee. I had buying agent commitment in there as well. But the initial CD got over the title, and it never came up, and it came up 5 days before closing, and it was an uncomfortable conversation.
And the buyer didn't have the money to pay you.
She had to go back and get, revise the numbers, and we ended up making it pretty much to closing on time. But it was, at that point, we were under contract for 30 days. I didn't want to be re-talking about commissions.
Sure.
Yeah, but that was a unique situation though, because she works for an attorney's office. And her response was, if I would have known I was paying for buyer broker services, I would have just simply had to, where I work. Yeah, a little bit bad. But yeah, it was interesting though, because I think that brings up my question. This is all topic. It was my listing, it was my first new agency represented one. I'd never done it before just because I didn't want to end up in a storm like that. But she contacted me. I had to sign a buyer broker, consumer notice. We wrote the contract, we wrote the offer, and I accepted everything.
And you had a listing first?
Yes.
Okay, stop there. We're going to talk about that.
Okay, thank you. Because
We're going to do that right now.
Somebody wants to represent themselves. They have to sign something to see the house.
Yeah, they don't. So the rule is you can't show a house to a buyer without a buyer's agency agreement in place. You can sign a buyer's agency. First of all, if a buyer calls you on your listing, you don't have to do it. You can show your own listings without signing, you have to give your buyer, if you put a sign out, when you get a call, you give the buyer a consumer notice, and that's all you need. And you have to tell the buyer, I represent the seller in this transaction. You will be unrepresented, but I can show you the house, no problem. And you have to sign a consumer notice for me to do that. I'll bring that with me, or I can send it to you in advance to look at. If it's a buyer who, if it's not your listing, and somebody wants to see 123 Main Street, then you have to have a conversation that in order for me to show you that house, I have to represent you. If you don't know me and you don't want to sign an agreement, we'll do it for 1 day. Or we'll sign a non-exclusive buyer's agency, and I'm your agent if you buy that property, because the non-exclusive buyer's agency allows us to put in property addresses. So that's how you get around that situation. So I was saying in the quick agency, the agency 101, you have a buyer come in, you sign them up, you're what? A buyer's agent. You go on the listing appointment, they like you, they like what Keller Brothers offers them, they sign up with Keller Brothers, she listed the house, she's a listing agent. Kelly Brothers gets a buyer call on her listing. She goes to show it. She gives them a consumer notice. She tells them she represents the seller. Now they want to buy the house. What does Kelly Brothers do? She does not sign that up as a buyer's agent. She just created dual agency. It was never designed to be created. It has to have existed, which means Kelly Brothers listed 123 Main Street, which is a 3-bedroom Cape Cod on an acre. 2 months ago, she signed up buyer Maggie Landis as a buyer's agent, and she's been looking for a 3-bedroom Cape Cod on 2 acres. Now Kelly listed that house. Now Maggie says to Kelly, hey Kelly, I want to buy that house. Kelly already has Maggie. Kelly already has the seller. She, by nature, she puts that transaction together as a dual agent. But I'm going to show you how you never have to practice dual agency, ever. So when Kelly sells, forget about Maggie. When Kelly sells her 123 Main Street from the sign column, she's selling her listing to a non-represented buyer. She gets all the money. She gets all the commission. She only represented the seller. Because when Kelly went on that appointment for that listing, what did she say to the seller she would do? Did she tell the seller she'll get him the highest and best price? Did she tell the seller, and I'm helping through all negotiations on the transaction? Now, she practiced dual agency. So Maggie says, Kelly, the house is listed for 400. Should I offer 390? I don't know. So Maggie puts 390. Now the sellers were saying, Kelly, she offers 390. Should we split the difference with her? I don't know. Kelly is as useless as tits on pool. She's useless. We're not losing. You can tell.
I'm not giving you that.
I mean, that's why we know for you. Now, if you did it, I'm not chastising, but here's how you can get it. Here's how you can always guarantee you're never in that situation. Because the minute the scale tips and one or the other feels that you told the other party something about and that gave them an unfair advantage, there's a lawsuit. And that's called undisclosed dual agency, because both people have to sign in writing that we understand dual agency. So how do you avoid it? When you're doing your listing contract, I'm going to come back to this. When you're doing your listing contract, so what are our 2 employment contracts with clients? When you're a buyer's agent, what's your employment agreement? Buyer's agency contract. When you represent a seller, what's your employment agreement? The listing contract. Both the listing contract and the buyer's agency contract has a special clause that says single agency addendum. None of my buyer's agency agreements and none of my listings ever leave this blank. I include that single agency addendum with both of my employment agreements. So when I'm sitting with my buyer, and I'm going to show you that employment agreement. Oh. Remind me to come back to that too. Like so much I'm sure it's actually structure. This is the single agency addendum, and here's the block I checked. And when it says broker only represents buyers and sellers in the same transaction when separate licensees are working with the buyer and the seller. Broker does not allow the same designated agent to represent both the buyer and the seller in the same transaction. In the event the buyer, so my buyer's agency agreement, in the event the buyer chooses to buy a property where the seller's designated agent is the same as the buyer's designated agent, which would be Kelly in this case, the broker will immediately tell the buyer, and the buyer agency contract will end to that property owner. So when Maggie wants to buy Kelly's house, because she promised her seller she will only represent them, she goes to the broker and she tells, because when she sat down with Maggie to talk about buying a house, she had the same form attached to her buyer's agency agreement. So Maggie already knew, because of the buyer's agency conversation and the initial interview, that I can never buy a house that Kelly has listed. So now that scenario works out. Hey, Kelly, I see you listed my dream house. Can you contact your broker and find out who's going to work with me? Because I want to make an offer. Now, for that transaction, Kelly loses Maggie, but what does Kelly talk to the agent who got Maggie? Referral fee. So not only does Kelly get all the commission for the buyer's, the seller's side, but she gets 25% or 30% whenever she negotiates with the buyer's side. And she kept her promises to the seller. And Maggie has someone helping her negotiate. You are useless as a dual agent. And if you include this agreement, this addendum in both your buyer and seller contracts, you will never practice dual agency. You'll never have to. I have won more listing appointments because I include this. And I commit to my seller that I will only ever represent you, and they say none of the other agents told me that. So I'm not chastising you for doing dual agency. We think we have to sign up that buyer when it's our listing, and you don't. You don't. You can sell a property to a non-represented buyer. And that form, which I am going to pull out because I do want you to see it. Somebody can pull that one zip forms. It's so easy. It's a half a page. It says, I gave the buyer a consumer notice. I confirmed they weren't working with the buyer's agent, and they understand that I don't represent them. Couldn't be clearer. It's called NRA. It doesn't stand for National Rifle Association. Non-representation agreements. So Kelly can sell her own listing to a call sign as a non-represented buyer. Now she has to ask them if they want representation, and chances are it's a first-time home buyer they are. So that's her opportunity to do a referral to an agent in the office and get a referral fee. But even if she can't, they'll say, well, no, I know somebody who will represent me, and then the consumer has their choice. Yeah. The worst thing she can do is sign them up as a buyer's agent. Then that scale of equality gets tipped. And now what do you lose? What do we all have in this business, the big party?
Reputation.
Reputation. Now the reputation for, and I'm not saying you were greedy, but for greed and wanting to collect all that commission kills her for future business. It's just not worth it. Now, I will say, this says that the broker does not allow this. This is where, this is a Brittany question. If Brittany's in there and could hear me invoking her name, they would have to, we'd have to have this in our policy, because here's the other thing you have to worry about. There are some, and that's because you did a good job and you did the right things to both people. It went to closing. Everybody's happy. There's no lawsuit. There's no undisclosed dual agency. I didn't know he was representing both parties. I didn't know he couldn't tell either one, so you did it the right way. You just took a lot of risks you didn't have to, but it's done and no effect from it. If there would have been an issue, there's chances that heirs and insurance companies will not cover your claim if it's based on a dual. So there are heirs and emissions companies that won't pay the lawsuit if it's because of dual agency.
Even if everybody agreed, it's all documented, it's very clear.
Yeah, so it's up to your heirs and emissions carrier, and I don't know. Do you know?
I'm gonna pull it up now.
Yeah, if our heirs and emissions covers dual agency, I don't know. I never practiced it. Cause I can you can get around it. There's forms for it. You can get around it. You never have to practice it.
It's so funny, this one, I did it because of unique circumstances, I ended up doing it to 1.5 on each side to help everybody save money.
And that probably is what saved you. 'Cause-
Yeah, truthfully,
Yeah.
so I ended up taking a major risk, not for much more money, and
Well, and that's what savvy buyers think. They're hoping that if I call Mike Brad. And I bought 10 houses, I don't really need an agent. Brad, if he's the only one involved, is gonna go back to the seller and say, look. I got the buyer, I still only represent you, they're not represented, but instead of charging you 10% commission like we talked about, I'm only gonna charge you 8. The buyer's hoping that he'll do, there are savvy buyers out there that hope that if they go right to the listing agent. We'll cut the commission, but that's up to us, they can't assume that, but sometimes buyers are savvy with that. Like I sold my own listings to non-represented buyers because they said to me, look, we looked you up and you have a good reputation, you have good reviews, we bought 10 houses, we don't need representation. We know you want to represent us, we're fine. And 90% of the time, the buyer says, no, I don't want representation, and I can refer them to somebody in the office. And 10% of the time, we lose them to somebody else because they have a relationship. So it is what it is. But this form, single agency addendum, is referenced on your listing contract and your buyer's agency contract. When I check the block by number 11, that my broker will designate. That does the broker in theory really get involved in this? I can usually refer to another agent, or if the broker does get involved, I go and ask the other agent, and what agent isn't going to pay your referral fee? Does any?
No, I wasn't raising my hand.
Fairly hard
No, I was just gonna say, also, don't forget, you set your referral fee. So like, I just had one, it's a client that I've been in a relationship with this buyer for 3 years and shown who knows how many houses. And then she wants to see one of my listings and I'm like, she's probably gonna write on it. I can set my own, I don't have to do traditional 20.
No, you can do whatever you want.
Yeah.
You can do whatever you want. You've just given somebody, they have to show her one house and they get,
Exactly.
so, but you see what I'm saying? How many in the room, oh, go ahead.
So we all just got the link for Make a Fix 2026 compliance that Taylor sent out, right? And so our new P&G guidelines are in there and it says the practice, dual agent, the practice should generally be avoided. Do with that what you would like, but
So remember, if they're not informed of the transaction, that there's a potential. First of all, sometimes errors and omissions won't even cover. You have to let them know upon the potential of a lawsuit, not when you're served the summons, or else they won't cover. So use the single agency addendum. I think it's very beneficial for you in both listing and purchase transactions. How many use the form today?
No, I think you talked about
How many are going to start using it in the future? And I'm telling you, it's a key to winning listings.
Yeah.
It puts your money where your mouth is. You're telling them you're doing all that stuff for them anyway, right? So when I get to this page of the listing, I say, and this is my commitment to you of everything I told you, I stick with you.
Gary, I think, I came to this class expecting obviously to learn about a lot about contracts and how to do this deal. But I feel like you're giving us just as much value from like how to actually win.
Yeah.
We're gonna do forms
But
too.
I really feel like this is way more than I was expecting and I appreciate it.
Oh, good, thanks.
in this room, what would everyone think is a fair referral fee for that?
I was gonna have the same for her situation. I did.
Yeah, we just had them, getting them ready to go buy or pre-approved, all I gotta do, and not, obviously, it might be complicated, might not be, but 50%.
Yeah.
Okay.
It was a layup, yeah.
I'm shooting for the fire.
What are you gonna get a receipt guys?
Yeah.
To be fair.
Imagine.
It's not free money.
Wait, yeah.
Oh, no, we do much less.
But I get that. But no, to your point.
I would say also the relationship. Yes.
Um,
You don't really think about it.
And I think it depends on how much time you have in with them.
Well, that's what she said, she worked for this fire for 3 years.
Yeah.
I mean, that's a lot of time.
Yeah.
A question came up on Zoom and I don't want to ignore those. Do they see me or hear me? I don't know.
Yeah, yeah.
Huh?
They can see and hear you.
Okay. You probably wish they could hear me. I just tell everyone, I'm very passionate. It's just my Italian in me. I'm passionate. I'm not yelling at you. I'm just passionate. Can you sell, what does the seller do when they want to sell something as is? If there's equipment that's being sold in as is condition, on the disclosure where you have the equipment list, you could say being sold in as is condition. But a house is always sold in as is condition. It's in our agreement of sale that the buyer has previewed the home, they've walked through the home, and they're buying it in its present condition. They're not buying it in an improved condition. They're not buying it in a less condition than what they saw. That's why the seller has to always make improvements and repairs after the house is listed and goes under contract. They're responsible for ongoing maintenance. But the buyer has the right to do inspection. But it is in our list, our sales contract, it's in bold print. They're buying the house in as is condition. And it's our responsibility to let them know that as buyers.
Is
Now-
that also in the buyer's agency agreement, that it says that you understand that if you buy?
It might, I don't know. I should know my some stuff. But remember, if you're selling grandma's house, and we know old people, if it wasn't broke, they didn't fix it. My mother had a Frigidaire dishwasher that the prongs, the plastic was breaking off the prongs on the rack and putting rust on her dishes. And I was like, Mom, I'm calling Lowe's, and next week I'm putting a new dishwasher in the house. Why? This one works. Mom, it's putting rust on your dishes, for God's sake. Dishwasher, it's not what you for. I said, I'm buying it. And then it's like, well, when are they coming in? Who's it gonna be? But it worked. Now, if we sold my mom's house and that 30-year Frigidaire dishwasher didn't work, when the buyer saw that house, what are they entitled to? They're technically entitled to the value of a 30-year-old Frigidaire dishwasher, which is $5. But what we're taking away is the function of a dishwasher, so we have to put a new dishwasher in, even though it's going to cost us $700. You see what I'm saying? So technically, they're only, but you can't find a 30-year-old Frigidaire dishwasher to put in it. So we put in new appliances, but being sold as is, it's in our sales contract. So keep in mind the single agency agenda, use it. The other thing, for a long time, Bright was not current with taxes. So the other thing I do whenever I get a listing is I take the total assessed value and multiply it by the total millage rate for that county and township and come up with a total. Then I go over and I make sure that the county, municipal, and school taxes add up to the same thing. So when I put my taxes in Bright, I don't rely on Bright doing it right. Where do you find those documents? Every county has their tax millage rates. So, for example, Cumberland County. That house was in Carlisle Borough, so I took, I don't know if you can see this, Carlisle Borough is 240510 for the total, and that's what's on my Bright page, and then I multiply each of the individual, the county, the township, and school. So those add up to the total. And then I multiplied the millage, the total assessed value times each of these three millage rates to come up with the individual taxes, and they total the same.
If they have a homestead extension is, or.
No, homestead exclusion is not going to be reflected in that. This is going to be total. I put the total face value in the multi-list. Homestead exclusion, the reason I don't ever advertise that tax amount is because buyers have to sign up for that. It's not given to the buyer. So at a minimum, the buyer's responsible to, and the most, I want to show what the face value of the taxes are in the multi-list. I don't want to show the reduced value, and I don't want to show the penalty value. I make sure that Bright shows the face value. Again, I'm sure agents don't go to this extreme. You just go with what Bright says. It goes to closing. But there for a while, Bright was really off on the most expensive one, school taxes. And what do we know about taxes? What does it do to the buyer? It's part of the what? Part of their payment. The buying time. Brittany, what are you starting with? Getting,
Gluten free, dairy free taco salad. We got. Sounds appetizing, that sounds good. Gary, I just wanted to interject, I looked at the buyer agency contract, it's paragraph 13, buyer inspections, it says right there that unless buyer and seller agree, otherwise the real estate is being sold in its present condition. So
okay, yeah, and we bold stuff. The other thing I wanted to tell you, and this is a plug for using PAR forms. First of all, the Real Estate Commission has rules and regulations. Then our Code of Ethics has rules and regulations. For example, when we have a listing and it goes under contract, do we continue to provide our seller with contracts on their house? Do we continue to collect offers and give them to them? No. And where does it say we don't do that? In our listing contract. So here's our listing contract. And there's a clause in here that says additional offers. Unless prohibited by the seller, if broker is asked by a buyer or another licensee about the existence of other offers on the property, and then once the seller enters into an agreement of sale, broker is not required to present other offers. See, that's in bold. That's because the Code of Ethics says, we have a Code of Ethics at NAR that says you have to provide all offers to your seller unless they provide in writing that you don't. So even if you don't understand your Code of Ethics and you don't know the law, if you use PAR forms, those attorneys have scoured over the state regulations and scoured over all of the Code of Ethics and made sure that the agreements we use comply with the state and the Code of Ethics. So even if you don't know what the Code of Ethics says or why it's in there, your contracts will protect you. And the other thing I'm going to send around is, so our listing contract right now is 7 pages long. Every PAR form, when you go on to PAR and you go to standard forms, it's going to give you a template of the form and there's going to be a guide to complete the form. So we don't,
We're gonna send it.
Taylor's going to send this to everybody. So if you're brand new, this is going to tell you how to fill out every line in the agreement of sale. So with, I'd say 95% of the forms. Remember the NRA form I just told you about, the non-buyer representation form? There's no guide to complete that because it's common sense. You gave them a consumer notice, you ask them if they're working with anybody, and they understand you don't represent them. 3 questions. There's no guide to filling out that form. But there's a guide to filling out the agreement of sale. So our agreement of sale is what, 14 pages? The guide to that is over 50-some pages long. The guide to fill out the listing contract is here, and I'm going to send this around so you can look at it. It's 23 pages long. The thing that's great about these guides is there's all kind of practice tips in here. These practice tips are the things that keep you from getting into the lawsuits. These are like the things you want to do to make sure you're doing everything correctly. So I'm going to send this around. You can just look at it. Taylor's going to send it to you. One of the things in there is, we're going to look at the listing contract. Now I'm just going to use one that I just did this week. It's current. Put your seller's name in all capital letters. You do that on the agreement of sale and you do it on the listing contract. Why? Why do you think capital letters matters?
So there's no confusion of what.
Right. Capital letters can't be confused with one another. If you do lowercase and I do this, is that an L? Is it an I? Or is it a 1?
Yes.
What's that? An I. And can it be anything else? Absolutely not. Why does it matter? The title company uses the agreement of sale oftentimes to determine what names to put on the deed. And the deed is the public record of who owns the property. You want it to be correct. So there's no mistake. This is wrong on my paperwork. So see, I do make mistakes. We never used to have company license numbers. So on the second line of, so this actually should be down here. But I had to, I have templates for all this stuff and I gotta go and change that. But anyway, you always start off at the top with who's the broker? You have to have the broker's license number, our address, our phone number, our fax number. And who's the licensee? Me, what's my license number? And what's my email address? Then who's my seller? And the seller, if it's an individual who's alive, it's his name. If it's an estate, I write the estate of name, comma, Gary J. Muccio, executor. If it's a woman, it's an executrix.
And you're saying.
And that whole name goes on there. Why? It goes on the disclosure. It goes on this. Why? Because you're telling the public it's an estate. And this is the person who can sign for that estate. So that's the name I use on the disclosure, on the listing contract, and I put in agent remarks for the agent writing on my estate listings. Seller name is, and I put it in all capital letters so that the contract's filled out right.
And then when the seller signs, so they can just, or the executor sign, they can just.
They're just signing Gary J. Muccio, and I if I was the executor of that estate, I would just sign EXEC. And if it's a woman, I would still just sign it EXEC. I just wanted you to know, never don't call a female an executor. She's an executrix. Okay. Now, same thing if you're doing power of attorney. If Kelly's infirmed and Maggie's hurt, so it's Kelly Carruthers, comma, Maggie Landis, POA. Showing that Maggie has, and you want to make sure when you list a house that you get a copy of that POA document. You have to have that POA document to show that Kelly gave Maggie the right to sell her real estate. And then you have a name if there were no documents done and you had to go get court approval. I think when you're court approved, you don't quote me on this, you may be either a guardian or a conservator or something like that, but your court document could say what you are. For the most part, we're just using buyers, or we're just using sellers who are alive and well, and everybody's name on the T has to go on that line. You have to have a mailing address. Believe it or not, this is important. You cannot make a mistake on the house number. You only have the right to sell the house that they own. If this says 1210 or 1280, because I made a mistake. I transposed numbers. Stephen doesn't own that house. I don't have a valid listing contract. Now, what happens if that goes all the way to settlement? Well, hopefully it would and no issue, but if there'd be an issue. So here's the thing. We're in an industry where our mistakes can cost us a lot of money. So I would say when you make a mistake, just go to everybody, tell them the mistake you made and how you're going to fix it. So if this is fully executed and I realized I wrote 1280, there's a form, a PAR form that says change to listing contract. And if the address isn't one of those changes, there's an other section. And you can just say address change to 1208 Lake Birch Lane. So when you make a mistake, you can correct it. This is why it's really important when I get a contract on this listing, that I make sure the agreement of sale has the correct address too. If the buyer's agent did put an incorrect address, because I don't have a contract to sell another house. You know the county, you know the school district. Zoning is important. If it's not residential, but they're using it for business purposes because they have a variance, that's where you would put it here. Who's it occupied? I just put owner of record, because that means the person who's on the deed. Then I identify where we know it has a parcel ID. You can get that. That's on tax records. That's on the deed. That's on the bright MLS tax record up in the corner. Then I pull the deed. And that deed had an instrument number. Every deed has an instrument number. And I go further and say when that deed was recorded. Because what does it say? What does it say for identifying the property? Put as much as you have. When does it start? When does it end? I do 6 months listing. How long can you have a listing for in Pennsylvania? 1 year. So listing contracts, our employment contracts with the seller are limited to just 1 year. How long can we have a buyer's agency agreement? Indefinitely. Didn't somebody just say they worked for somebody for 3 years? Yeah, so it's indefinitely. You're going to put time frames on your buyer's agency agreement, but then you're extending. So there's no limit on the buyer's agency agreement. On a listing contract, you can only list, and that's in the Pennsylvania law. You can only have a listing for 1 year. Now, this talks about dual agency. And it says that seller agrees that broker and broker's licensee may also represent buyers of the property. So technically, your listing contract is giving you permission to do dual agency. But when you explain dual agency, and you explain that this is counter to what you promised them, then you show them the single agency addendum that you will not practice dual agency. There are companies out there where they would check designated agency is not allowed. We have a couple boutique agencies in our area where every agent, so if this was my company and you were my agent, and we're bringing people through the door, every one of them, whether they're a buyer or sellers, are represented by all of you. So that means if you sell one of our company listings, you're always the dual agent, which is really bizarre to me. Because let's face it, do I know your clients? I barely even knew who you were. Let alone do I know your clients? No offense.
No.
It's the first time I've ever worked at a company where I don't know every agent in my office. But anyway. So I don't know your customers. How do you build a business based on your relationships? Your relationships with people are based on your reputation. I don't know who they are. So I just don't get it. But... And definitely you want to be, you're a designated agent when you're selling a Keller Williams listing. But we're always designated. As long as your clients are only your clients, you're always a designated agent. That means you're the one designated to that person in your brokerage. Definitely when it's in-house, you're a designated agent because whatever we are, if I'm a buyer's agent, Scott's a buyer's agent. If I'm a seller's agent, Scott's a buyer's agent. So we're arms of our broker. Whatever we are, our broker is. So when I have a listing and Maggie has the buyer, we only have one broker. So Maggie's designated to the buyer, I'm designated to the seller, and Scott's the dual agent. So on the form, broker's dual agent, Maggie's designated to the buyer, I'm designated to the seller. So in-house, it's huge that you say that. But even when I'm selling a co-broker, I want the co-broker to know I'm the only one at Keller Williams who is designated to that buyer. We do not share buyers and sellers in this office. So now this is really important. And then we'll try to get through the listing contracts. There's one other thing I want to show you. This is where I have the right to say what my fee is. Now, this is in total. On the next page is where I say whether I'll share and co-broker. So I explained to my seller, I'm willing to give 2.5 of the 4.5 to a buyer's agent. Or I don't have to co-broke at all, and I want at least, so if you put a number in 6, it's coming out of what you put in 5. So if you co-broke, it's coming out of 5, and it clearly states that in here. It says, for paid from broker's fee. Broker's fee was on page 5. So the total to them is 4.5, and I'm giving 2.5 away. You're probably thinking, wow, Muccio, you still have such a cheap. This is a personal friend, so that's the beauty of what we can do. We can do whatever we want to do. I can sell it for 6 donuts. And I love donuts. I'll sell it for my share of my Carbon Farms beef share, right? Anyway. Or I say, I want 3% or 3.5% on the front page. And let's just wait till the buyer asks what they want. So I give my sellers 2 choices. I can either charge you a full amount and share some of that, in which case 5 is the total. This is what I'm giving of that total. Or I just put what I want on my side, and the seller says, I don't want to pay a buyer's agent. Let them ask us what they want in the contract, the agreement of sale. So your seller has 2 choices, and you have to explain that to them. But if they're willing to co-broke, you put the co-broke amount here. Then, when I get a call on my listing, I text the agent, because I don't want a phone call. I text them and say, thanks for showing my property. Seller is offering 2.5% co-broke on this property. Then you go in and you know. Now, if you're the buyer's agent, you can say, okay, my buyer's agency agreement says 3%. So on that $100,000 house, my buyer's agent fee is going to be $3,000. And I know I'm getting $2,500 from the seller because Gary told me up front. So now you can tell your buyer before they even go look at the property. By the way, if you look at that, Muccio is only offering, the seller's only offering $2,500, but I'm going to charge you $3,000. Or you can say, I'm going to go in and change your buyer's agency agreement and accept 2.5%, and you have to initially engage that. Now you say, well, why would I do that? What if I don't get the house? You do it after you know you got the house. Because now if you don't change your buyer's agency contract, you have a legal document that you could use against your buyer to collect an extra $500 when you said you wouldn't do that. And the buyer's not going to realize that, but you're the one who does the paperwork. You know that. So you should go in, even if it's after the contract is executed. Once you know you got the house and that you're willing to accept this, and you're changing your fee to $2,500, and the buyer owes you nothing, that's when you should go back and change your buyer's agency agreement as well. Now, the reality is, agents don't do that, but we also don't go after them after settlement, charge them. We honored our word, our paperwork doesn't match our work. See what I'm saying? So just some things to remember with our paperwork, keeping it clean, updating your buyer's agency cost sheet, updating your buyer's agency agreement when you're done. I leave seller concessions all blank because I don't want my seller to say what they're going to give. I leave it blank and let the offer. Here's the reality: the Department of Justice and the federal government does not want us to co-broke. They want us to eliminate cooperating compensation in its entirety, and they're not done looking at us yet. So I think it's going to change. But in Pennsylvania, co-op compensation is still allowed, so we're never going to take it out of our forms. It's allowed, but there are states that don't do it. When you do a listing, you tell the seller what you want, what your services are worth, and the buyer will ask the seller what they want them to pay. It's always negotiable. Delaware doesn't have CBC. I don't think Texas does. There are states that don't have cooperating compensation. And I would say by going to the PAR meetings, we are about 50% of the way, 50% of our agents want it eliminated, and 50% of our agents want it to stay. They feel there's an advantage to it.
Very quick question. So if they're looking at open-ended, you don't have to put any language in there at all, just all be blank.
I leave it all blank and let come through what's on the contract.
And so the only time that you would be able to say yes, because when you fill out the back end on Bright, when you're putting a listing on, you can say yes or no to concessions.
I always say no to concessions.
Even if they're offering the co-broke, you say no?
Yes, I do, because that's not a concession.
Okay.
I'm co-broking. I view concessions as we're willing to give up this much towards buyer's closing costs, because that's really what concessions mean. I'm willing to contribute $5,000 towards buyer's closing costs, one of which is a broker fee. But I can't say how the buyer applies that. My concession isn't the compensation to match the buyer's agency fee. It's just, here's money towards the transaction, apply it how you want. Most of the times, it's in the amount of what's on you're asking for what's on your BAC. And as a buyer's agent, you all know the law says, if I told Dreamer, hey, my seller wants this house sold so badly, he's offering 4% Cobra. And Dreamer's buyer's agency says 3, he can only take 3. Now, if he takes, I have no right as the listing agent to ask him for his buyer's agency agreement. That's between Mike and the buyer. I have no right to ask for it. If he takes the 4, he broke the law, not me. We're not out to police other agents. I've had agents ask me for my BAC and I tell them I'm saying, you're not getting it. That's between me and the buyer. I had 5 offers on the house and they wanted to see my multiple offer summary worksheet. No, you're not seeing it. You lost, you didn't come in, you didn't net the most to the seller. That's the way it is. I send an SRP back to them that proves that the seller saw their offer, the seller signed it. I don't have to give that kind of documentation. You don't have the right to ask another agent, did you do your job the right way? Form-wise. Go ahead, then I'll come back to you.
So, because you taught me that, that's how I understand the BAC function, and also that's also what title attorney says as well. But there's nothing that stops you from going back to the
And changing it.
4.
As long as your buyer will agree to it.
Yes.
Yes, there's
You're
nothing that.
buyer, they're gonna give you 5% on this one, may I get it? Yes, please, initial year.
There's nothing illegal about your agreement with that buyer to go higher.
Do you have to change anything if you?
Now, some people would, I'll get back to it. Some people would say, well, if we're getting more than what you wanted, should we give that towards the buyer as a concession to lower their closing costs? So, but there's nothing wrong. So that's where ethics, morals, what do you want to do to increase your reputation and add value to your buyer versus what's legal? Can you change it? If your buyer initials it and you get all the money, absolutely, absolutely. Then you go.
What's everyone charging for a broker fee?
Can't talk about it. We should talk about it. Let's not talk about it.
All right.
That's the end of it. It still makes me nervous because I know we're one company, but that still makes me too nervous.
All right.
Talk to them outside when I'm not in the room. I'm so programmed to don't talk about that. Go ahead.
That's what I was gonna ask. So if they're giving 4, you have 3, you have to fill out anything different to give them that 1% towards their point.
Well, if I were to read, and I'm sure he would do this, if he had 3 on this thing and they were giving 4, he would fill out the co-op compensation form with 3 and put 1 in the contract for seller concessions towards his buyer's closing costs.
So you would do that on the offer?
On the offer. So when I submitted the offer, I would give the buyer the extra 1,000 in concessions, and I would do a CBC to between the 2 agents.
So what if they said, we're not gonna have a CBC, want you to put it in the offer?
Yep.
You would do.
Or agent compensation on the agreement.
Then still on the agreement of sale, you would put it at the 2 bodies. Yes.
One more thing is, I hope that this doesn't take us too into the weeds, but if there is not a COBRA on the listing agreement and you receive escalations with your offer, you have to deduct the buyer agent compensation that's written into the agreement before you can add the increments of the escalation, right? Like you have to factor.
And she says, remember, the price escalation addendum says net purchase price. So you can't consider if the buyers are paying both sides of the transfer tax, that comes into net proceeds. Your seller should be making the decision based on net proceeds, but you have to come up with a price to escalate offers with. That price is the sale price less any buyer's closing assistance, which is considered concessions, because you don't know if those concessions are going, what closing costs they're going to. So that's where you have to be careful when you're doing price escalations. But you know that up front, if on that listing you offered CBC or concessions.
But if you didn't offer CBC or concessions and they're just writing in like under, what is it, 13A, that say 2% is going to go towards the buyer agent fee, does that have to be deducted?
No, that can't be deducted. No, that comes into the seller's net proceeds.
That's what I thought. But
Yeah. And that's. Real estate agents can't do math. They stuck at math. And I say, if you can't do simple addition, subtraction, multiplication, and division, put your license in the shredder and do us all a favor. It's ridiculous if you can't do math. You make six figures easily, and surgeons make six figures, and they go to school for 12 years. You need a GED to have a real estate license. Come on, folks. Come on, folks. Step up the game and understand what you're doing.
But if you're working with if you're not asking for a COBRA and you get multiple offers that escalate that have different buyer's agency commissions that.
Well, concessions, concessions. We gotta factor that into the.
Have to factor that in.
Well, even if you don't want to, you gotta factor it into price to come up with what your final sale price is.
Right.
I'd like to see a PEA. We'll do that on Thursday. We'll start with that. I want to see if the PEA was revised to say concessions or towards buyers. But if buyer's closing costs, remember, your fee is a buyer's closing cost. So it's a legitimate closing cost. So if it's all concessions, that would get subtracted from the sale price. But we'll confirm that. Let me just continue on here. I think, when I'm going over this, I tell, this is my dialogue to the seller. At the same time I'm working with you, I'm offering services to the buyer. I'm not responsible for any damages in your house. If somebody breaks something, the buyer is going to have to pay for it. But because of that, don't leave precious, expensive knickknacks sitting at the end of the counter. I tell them, don't leave prescription drugs out. Don't leave jewelry out on your dresser. I am not with the person looking at your house. People will steal stuff, and I'm not responsible for it. I tell them that the state has laws for us on how we deal with deposit money. They know we list other properties at the same time we list theirs. Once we get an offer, we don't have to continue to give them other offers. They have to reveal all defects of the house, environmental and otherwise. The disclosure will take care of that. And if it was built before 1978, they have to fill out a lead waste paid form. If they want to market their home with a home warranty, they certainly can. It's available and they can use that. And I remind them, you cannot record people's voices on your property. You can photograph people in your house, but you can't record their voice. It's against federal wiretapping laws. And if they tell you I'm recording them anyway, you might not want to list the house because you will be dragged into that lawsuit too. We go over the recovery fund on the consumer notice. I tell them it's in the listing contract and I tell them it's going to be in the sales contract. I tell them you cannot discriminate on who buys your house. It's against federal state laws. All we care about, are they qualified? Are they green? Do they have enough money? The only color you care about in real estate is green. Do they have money? If our company is going to sell our company, then this contract will be transferred to the new broker. There's no intentions for us to sell our company. You enter into no other listing contracts other than this one. If there's a conflict of interest, we have to notify you immediately. What would be a conflict of interest if my sister wanted to buy your house? Can I give them an example? Changes to the contract have to be in writing, and then we get into marketing. Whether we're going to use the MLS or not, this is where we have to give them the, we have to have the Bright disclosure because Bright wants to remind them, don't do an off-market listing. It's very negative about an off-market listing. You get the highest and best if you list it, but there are times when a seller doesn't want to list their house. If a seller's immunocompromised and doesn't want people parading through their house, and they say, we want you to market the house to buyers who might want it. And we're fine if we don't get the highest and best price. We're fine if it takes a while to sell it. We want it off market. We don't want everybody parading through our house. There could be a reason for that. I always check that we're not going to allow hyperlinks with comments and reviews or any type of estimates. I remind them that I can't change the estimate that's out there. And I am going to use a delayed marketing tactic. In this case, I said we're going to have coming soon as a status in Bright as of 4/6 yesterday, and we'll be active as of 4/9 on Thursday.
When you're doing putting the listing in through the MLS, I deactivate the APR.
Yes.
Okay, is that the same thing as?
Yes, that's where you check it. Yes, that they don't want comments or estimated values. Yes. We don't publish the purchase price until after closing. I remind them that there's going to be photos of their house on the internet, and I don't know those copyrights to those photos. They're not necessarily mine. If they're okay with that, What stays with the house, make sure you list everything that they want with the house there, if there's any window treatments or not, go through all that ahead of time so that you don't have these issues at closing. What's rented? I asked, there's propane tanks in the backyard. I asked them, do you own those propane tanks or are they leased? Because then you have leased propane tanks. Are the solar panels? Solar panels are huge with a listing. If you drive up to a house and you see solar panels, that's going to be a difficult listing if they're leased. Because what do we know about these solar panels? The new buyer has to take on that lease.
It has to qualify.
And has to qualify. And it may not only do they have to qualify for the solar panel company, but the solar panel company, they have to make sure that that payment makes them qualify for their mortgage too. Yeah, so solar panels can be a nightmare. I've not seen a windmill yet, and I hope I'm retired before windmills come on board. I think they're great, but I don't know, I've never sold a property that had a windmill. I did sell a property that had a cell phone. And they did receive some revenue from that. And then what's excluded? So if they want the window treatments that match the bedspread, that match her wallpaper, you know, put it in there. Put the taxes in. I calculated the taxes. I knew what the assessed value was. They're not included for a tax abatement. We know the HOA, we have a phone number, we know there's been special assessments because we asked the seller. We know what the buyer's capital contribution is because I called the HOA. We know what the monthly fee is because I called them. And there were no municipal assessments because I asked them. FERPTA, are they a foreign investor in real estate? Most of your sellers probably are not going to be a foreign investor in real estate. Who do they have mortgages with? What's their account number? What's an 800 number? Because we're going to have to get a mortgage there. Do they have a second mortgage? Do they have a line of credit? Do they have any other judgments that are going to be liens against the property that have to be satisfied when they go to closing? If no, then I type all that in there. Do they owe child support? A seller has to give their social security number to the title company because the title company is going to do a domestic relations lien search. If you have a deadbeat dad who hasn't paid his child support, he's not going to sell his house without that child support in arrears being paid. That's a lien against the property. So there's many liens against the property, not only the mortgage and the home equity line of credit, but then you have to do taxes, federal tax liens, state tax lien, and child support. All lienable against the house. So you know these by asking the seller. This seller only wants to do cash and conventional mortgage. They don't want to deal with FHA or VA. Now, if I get a VA offer on this property, do I have to present it to the seller? Absolutely. All offers have to be presented to the seller. That gets me to my next point, and then we'll end here. What do I have checked as a special clause? Now, if those of you who've taken my class before, I'm only going to tell you 2 more things and then we'll wrap it up. 1, I hate love letters. Hate them. Why do I hate love letters? Because you are providing your sellers with information that makes them violate federal fair housing laws. If your seller is influenced by the buyer and who they are, and they sell the one party over another party, and one of those parties was a protected party, you've provided your seller with information that will get them into a federal, not just a state, a federal fair housing lawsuit, and your ass is going down with it. So, when I would get them, I didn't present them. However, I learned from talking with Jim Goldsmith, every piece of paper you get with an offer, you have to present the seller. You're required to present all documents you get to the seller. So even though I was doing the right thing to protect my seller, unless it's in writing from my seller giving me that instruction not to present love letters, I have to present love letters. So he said, what you're doing is correct to protect your seller. But where you're breaking the law is you don't have permission from your seller to not give them love letters. Well, that only took me one time talking to Jim. And now I have language in all of my listing contracts that says, seller hereby requests that the listing agent, when presenting offers to the seller on the subject property, do not present any personal letters or photos submitted by the buyer that could be deemed discriminatory in any way or lead to a potential violation of fair housing laws. This does not include information regarding the buyer's financial qualifications or ability to purchase the subject property. That means that if I get financial information about the buyer, of course I'm going to present that. But I don't present any photos or letters. And now when I get them, I don't have to present them. That's why if you see listing agents write in agent remarks, don't do highest and best, no PEAs. That's bullshit. Call them out on that. They have to present everything that you gave them. Now, that's where I said, because they can't do math. Agents can't do math. But what's the reality then? If your Muccio says you can't present those, and you know that I don't want them, then you're competing. When you send me one, now you're hurting the buyer's chance to get your house, and that's wrong. So I push the agents on that as they have to present it in the end. They can't, that's not a statement that can be held up. If you find out your offer wasn't presented in fact, unless the agent seller instructed them to do PDAs, and what seller is going to do that? Do they have it in writing from the seller not to present any PDAs? You following me? So if you're an agent who doesn't want to deal with that, you better get it in writing from the seller. And how's that conversation going? We don't want to bid the price up. We don't want escalation clauses. What seller's going to say, yeah, I'll put that in writing? You see what I'm saying? So just make sure you have it in writing if you're not going to present love letters. And I would not present them, and I would definitely put that in writing.
What did you say about highest and best? Not to use that?
Well, if you're an agent, you often see in agent remarks in the multi-list, highest and best offers only, no PEAs, price escalation addendums. And that's really nothing, you can't really do that unless you have it in writing from themselves. Remember, you can't do anything. You can't even, I don't know, there's a lot in Carlisle, if you work in Carlisle, there's a lot in Carlisle that's on South Anderson Street, and it's a vacant lot. Right when it merges into one lane, that vacant lot on the corner, and I forget what company has their sign in. But every week, they were advertising a spec home on that lot. And every week, I don't know if you noticed, they were dropping the price by $100, then up $100, then down $100, then up $100. It was annoying. They were just trying to get that house out there. And I don't report people. If I have a problem with an agent, I go to the agent first. If I find I'm just running my headed to the wall and I'm getting nowhere, then I'll call the broker. On this one, I was tired of it. I hit the correction button and I typed to Bray, hey, I guarantee you this agent does not have written permission to change this price weekly. I said, would you please investigate? Well, that listing stopped coming up every week with $100 higher, $100 lower, $100. You can't do things without your seller's permission. So, I forget what the other thing was I was going to tell you about listings. I said there's two things I want to tell you. But this is a big one with love letters, don't do love letters. And then sometimes we just get into the habit of having the seller initial every line, but if there's no lead-based paint, it doesn't apply, we don't sign that line. And then everything in bold is important. That the seller receives a consumer notice, it's read the entire contract, they give permission to send information about the transaction, the fax numbers and emails that were listed, so we have permission to email our seller. And you have to give sellers copies of everything the day they sign it, unless you have permission to delay that. The other thing that's really important, you see all of this is in writing. I physically sat down and noted it. You can do DocuSign. I'm not saying you can't, but there's a standard of practice 9.2 in the Code of Ethics that says if you're going to use electronic communication, you have to have a phone call or a Zoom call and go over every line. You can't just say, sign this. Here's a high level summary of what you're signing. You have to explain everything that's in this contract as though you were sitting down with them. DocuSign does not prevent you from your responsibility to explain everything. And then always use your single agency then. So we have 3 minutes. I'm just gonna go around the room. What's one thing you learned today that you didn't know before you came in, or one thing you're gonna do differently next time?